morning, everyone. Welcome to our first day of the spring oral argument session here in Philadelphia. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May of 2022, we celebrated our 300th anniversary with a special session in Old City Hall here in Philadelphia. We on the court are very proud of our rich history. In 1996, 274 years after the establishment of our Supreme Court, Madam Justice Sandra Schultz Newman became the first woman ever elected to our Supreme Court. On September 9th, 2025, we gathered in this courtroom to bestow a very special and well-deserved honor upon Madam Justice Newman by renaming this historic courtroom the Madam Justice Sandra Schultz Newman Supreme Court courtroom. Sadly, Justice Newman passed away last month on February 2nd at the age of 87. Justice Newman was an inspiration to me and to countless other women in the judiciary and to those in the legal profession. May her memory be a blessing. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please do not interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues that we wish to explore further. I remind you that we do not permit rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. Good morning.
Good morning.
In 2021, the City of Philadelphia passed an ordinance that was designed, among other goals, to ban weapons commonly known as ghost guns, including the use of three-dimensional printers to construct such firearms. In this appeal, we consider whether the ordinance is preempted by the Pennsylvania Uniform Firearms Act under either express or field preemption principles. We also granted review to address whether waiver applies when a party bringing a claim pursuant to the Pennsylvania Constitution fails to formally brief the four-pronged protocol used in analyzing state constitutional rights as set forth in our seminal decision of Commonwealth versus Edmonds. Please proceed.
Good morning, Your Honors, and may it please the Court. My name is Gilbert Ambler. I'm joined today by co-counsel Oliver Krabchek, who's in the gallery and will not be arguing, and I represent Gun Owners of America, Gun Owners Foundation.
Where is he? Oh, he should come to counsel table, and we can see him.
Thank you, Chief Justice.
Yes, welcome.
And alongside Gun Owners of America and Gun Owners Foundation, I represent 4 individuals who desire to lawfully build firearms within the city of Philadelphia. And in this case, the General Assembly has expressly preempted the field of firearms regulation in Pennsylvania This court has indicated that the field of firearms is preempted in Pennsylvania. The Commonwealth Court has said that the field of firearms is preempted in Pennsylvania several times over. And to paraphrase Justice Weck during the 2023 Crawford arguments, what part of no don't you understand? And here, we believe that the Commonwealth Court got the correct result, reached the correct result, when they determined that the field of firearms was preempted, but then proceeded with a wrongful analysis to conclude that this ordinance was not preempted under field preemption, nor under express preemption. And turning to the language of Section 6120, the title of the statute demands uniformity. The language of the statute, prohibiting regulation in any manner, is an express, explicit prohibition on local government in any manner regulating firearms. The legislative history in this case is indicative of field preemption. Why would the Uniform Firearms Act direct how to carry in Philadelphia, for example, under 6108, if they did not intend to occupy the entire field throughout the Commonwealth? Alterations, whenever the city of Philadelphia or other localities or municipalities have attempted to find a crack in preemption, the General Assembly has amended and altered to fill those cracks when they have popped up to ensure that there is a clear understanding that the field is preempted. This comprehensive regulatory structure is similar to other places in which this court has found the field to be preempted. In fact, very recently in the Crawford decision, this court described the Uniform Firearms Act as a comprehensive regulatory structure. And of course, that language is similar to things like the regulation of alcohol, the regulation of public utilities, and the regulation of the banking industry.
Counsel, if I may, share with us your thought between 6120 and 6105. 6105 specifically, the legislators specifically used the word manufacture, yet it's not in 6120. What is it in 6120 that you manifest the manufacturing aspect?
Judge, I think that it's the very genesis of the item in question. And so the fact that 6105, in fact, considers manufacturing, we think is evidence of the fact that the General Assembly very much intended to preempt the field, including defining who is allowed to manufacture a firearm.
Why wouldn't they just use the same word in 6105 and 6120 if we were to follow your theory?
Well, because when they talk about ownership, ownership has to naturally encompass something being made at some point. There's no ability to own or possess something if it never gets made in the first place.
Let me ask you a question that sort of may seem a little bit off track, but I don't think so. In studying the language of subsection A of 6120, and you spend a lot of your time dealing with this statute in these types of cases, could you tell me what the term "when carried or transported" modifies in section 2160? No county, municipality, or township may in any manner regulate the lawful ownership, possession, transfer, or transportation of firearms, ammunition, or ammunition components when carried or transported.
That's a good question, Your Honor, and I think that what they're talking about here is targeting towards the transfer portion of the statute. And so when you look through the scope of the Uniform Firearms Act, there's in 6109, for example, in 6108, there's multiple examples where they define how a firearm can be carried, how it can be transported, in what ways it can be moved at all. And I think what they're doing is they're saying, this is what we're trying to preempt.
That's what I'm asking you. I mean, are they attempting to preempt regulation when firearms are being carried or transported?
They are, Your Honor.
Okay, so that term modifies firearms, ammunition, or ammunition components, correct? So the only thing that this is intended to do is preclude regulation when firearms are being carried or transported.
I don't believe that that's consistent with this court's prior decisions in Ortiz, for example.
Well, that's interesting because I don't think we've ever looked at the words of the statute.
Well, in the Ortiz case, they considered 6120 as a whole, and they found that it preempted a statute that prohibited certain types of weapons as well as accessories of weapons.
But we didn't actually consider what carried or transported modified in the context of Section 6120. And if what we're talking about is correct, certainly the regulation of manufacturing has nothing to do with firearms when they're being carried or transported.
I think the zooming out and looking at the statute as a whole, they proceed to say in any manner. And I think what they're getting at here is that they're not trying to limit it quite as specifically as perhaps you're proposing carving the statute
but
up.
in any manner precedes the rest of the language in the statute. So it's, you can't regulate in any manner when firearms are being carried or transported.
And that would stand in direct conflict, if you were to read it that narrowly, with the broader protections of Section 6120. Because
But where did the broader protections can only flow from the language of the statute, correct?
I would agree, Your Honor, but to target ownership and possession and then separate ownership and possession out and say all we're worried about here is the transport of firearms.
But it's carried or transported. Carried has a very particular meaning in the context of firearms.
And it's defined under Section 6109.
Correct.
Yes.
I mean, what you're suggesting is when carried or transported is meaningless.
I think that I see it conversely, which is that would make the ownership or possession portion of the statute meaningless if we said that the statute only preempts carry or transport regulations. We could forget about the ownership and the possession portions of it if that's all they were looking at. Then it would be transferred.
Well, there are possessory crimes that arise as a result of carrying or transporting.
There are.
I mean, some carried or transported has to mean something within the context of subsection A of 6120, and I'm struggling with what it could mean otherwise that regulation of firearms is precluded when they are being carried or transported.
And that reading of the statute would then allow the localities to come up with statutes that governed the ownership or possession. And I think clearly
Outside of the context of when they are being carried or transported.
Yes. And I think that's the argument that you're sort of laying out right now, is that to say as long as they're not being moved around, we could regulate them inside the home, for example, because they're not being carried or transported. And I don't think when we look at what this court has done, what the General Assembly has done in response to firearms ordinances that have popped up in various locations, I don't think that's consistent with how either this court or the General Assembly has treated this statute.
I understand that, but our case law has never really focused on this language.
And I would like to answer your question. I also would like to answer whatever Justice Weck is about.
I just wanted to follow up on Justice Donahue's question by asking you, because I also noted those words at the end, can a firearm be lawfully owned, possessed, transferred, or transported in circumstances when it's not being carried or transported?
Yes, a firearm could be owned or possessed in circumstances where it is not being carried or transported. But I think if we were to read Section 6120 as applying only to the carry or transport of firearms, it would make the ownership and possession start of the statute a nullity. What's the purpose of including the ownership or possession if all we're really trying to protect against is restrictions on the carry or transport of firearms? Because
you also can't regulate the lawful transportation of a firearm when carried or transported. I mean, that would be the construction, would be regulate the lawful transportation of firearms when carried or transported. That seems to be redundant, doesn't it?
Well, I think it makes it superfluous language to say.
That's transportation twice. You're regulating transportation. You can't regulate transportation when you're transporting. Well, I mean, but isn't it possible that the carried or transported language refers to ammunition components?
That is an alternative possible reading.
I'm sorry, I didn't hear that. What is the alternative
It
possible?
refers to
That
ammunition components when carried or transported.
And what rule, how would you support that interpretation of Justice Brobson?
well, I think we're getting into statutory construction
Well, that's
canons
what
at
this
this
is
point.
about. That's what we're here for.
That is true.
It is to be fair, not a construction that anybody in this litigation has offered. But
Well,
we get to construe the statute even though nobody has made this construction argument.
I think the placement in the statute, it's tacked on the tail end there, and the question Justice Brobson has posed in how could it relate to ammunition components shows that the proximity in the statute is that it is intended to modify perhaps the carry of ammunition components at that point. To tell the truth, the ammunition components portion of the statute I find to be a strange statutory construction in the first place, that ammunition and ammunition components were modified in that way.
Strange construction or strange word choice by the General Assembly?
Well, both, Justice. A strange word choice and a strange construction. I understand the questions relating to statutory construction here, but I think, as Justice Brobson referenced, the fact that no one has argued or briefed that in the past, and there has been quite a bit of litigation on this statute, and the General Assembly has decided at times to amend the statute in response to some of the cases that have popped up, amended it.
But if we read the statute in the construction Justice Brobson offered there, that would avoid conflict between the carried or transported language and the ownership and possession language, wouldn't it? Because if the carried or transported were understood to refer to the ammunition components, then the ownership and possession language could be understood to apply to firearms without reference to the carried or transported. Wouldn't that be true?
And to answer that question, again, I think that would be a odd construction, although albeit a possible construction. And the reason that would be an odd construction would be to find that the statute wanted to protect the possessory elements of ownership and not protect the possessory elements of, or the transportation elements of ownership of a firearm. You know, you're able to own a firearm, but we're not going to explicitly protect transporting it. But then when we get to ammunition, we're going to explicitly protect the transport of ammunition.
Oh, but it's going to protect ownership, possession, transfer, or transportation, but only when carried or transported. And I think Justice Wecht is saying, if we interpret this carried or transported clause to only apply to ammunition components, that would make the rest of the statute the rest of the provision make sense. If you don't interpret it that way, there's an internal conflict. I think that's the question.
And that, I think, is a sensible reading. At that point, you don't necessarily have explicit protection for the ownership of ammunition or ammunition components that way.
In this reading, you would. If you say no county or municipality may in any manner regulate lawful ownership or possession when you carry or transport, that wouldn't provide the protection that you're arguing for.
Correct.
But if you limit when carried or transported to ammunition components, ownership and possession are protected.
Yes, Justice.
And in order to do that, we would have to read some conjunction in between firearms and ammunition, or ammunition components when carried or transported, and ammunition or ammunition components when carried or transported, but that's not how it's written.
That is not how it's written. That's not the phrasing, but again, the proximity and the duplicative nature of what is being protected here indicates that the General Assembly was up to something where they thought that there had to be protection for ownership of firearms.
Thank you.
And I think that that's important to turn to these other cases where we've seen this court find that the field is preempted. because when we look at that broad language in any manner, I think that that is similar to situations, for example, where the alcohol and the banking industry, neither of which say field preemption, by the way. When they talk about those industries, they're looking at the scope of the regulation, and they're looking at how comprehensive that regulation is. And here I think that I had the question previously on Section 6105 and the term manufacturer from Justice Doherty. I think that that is good evidence, in fact, that the field is intended to be preempted here, because although they did not use that word in Section 6120, and Section 6120 has changed some over the years, I think the fact that that is something that the General Assembly is thinking about, and it's an area that the General Assembly is legislating in, shows us that they intended to be the ones creating the laws in that field. And so they intended to come up with who's eligible to possess firearms, who's eligible to make firearms, etc. And so when you look broadly through the Uniform Firearms Act, there are things relating to carrying firearms, there's things relating to loaning firearms, for example, that they govern. And they don't say in Section 6120 that loans on firearms are preempted, and yet they legislated in that area in a manner that shows they intended to be the ones who planted the flag in the field to say we are the ones who can make and legislate in this area.
Is it your position that if every individual in this courtroom had a 3D machine and we all went home and we printed our own firearms, not registered, not tracked, that's what is permissible?
Well, I think that there is more governance than just saying everyone can do this, because they do set forth classifications of persons that would be prohibited from doing that. Assuming you're eligible to possess firearms, then yes, I think that 3D printing of firearms is something.
What would stop, under your theory, what would stop a 12-year-old who's operating a 3D machine to make his own gun he takes to school?
There's a prohibition on firearms on school property, which is 18 PACS Section 912, I believe.
I'm well aware of it, but the issue is the manufacturer.
Sure.
The 12-year-old's making a gun. In essence, what I'm trying to overcome this hurdle of yours is that it's your position that the government, through its police powers, doesn't have the right to regulate the manufacturing of a firearm because of 6120. Yet the word manufacture is not part of that. You are gleaning that based upon your perception of manufacture in 6105 and not in 6120. I'm really struggling with that.
I'm gleaning that from the term ownership and the term possession, because there has to be some ability to acquire a firearm in order to own it or possess it. And there's been multiple cases that stand for the proposition that the local government is not able to govern the manner of acquisition. And so this would be things like the permit to purchase laws that have been proposed and that have been struck down. That governs ownership of firearms through governing the acquisition of a firearm. This is simply a method of acquiring a firearm in order to make a firearm, and that is one way. And you know, the law, the Uniform Firearms Act, does govern possession of firearms by minors. So that is something that is already unlawful. So when you ask, and so I was working backwards, starting with the school property, but the Uniform Firearms Act does address that scenario.
But
That's
but following your theory, the child can still make a 12-year-old can make his own gun in the house and hand it up.
Not lawfully under the Uniform Firearms Act, because the Uniform Firearms Act already prohibits minors from possessing firearms.
I'm well aware of the statute.
So under my theory,
I'm still trying to, I'm concentrating on the word manufacture, not bringing in 61, the other statutes out of 61, underage or concealed weapon in Philadelphia, none of those. I'm asking specifically the word manufacture, because I still am not agreeing with your argument. I'm trying to perceive it.
So correct. Under manufacture, when they set forth classifications of persons, they did not specifically address minors, although they otherwise addressed minors. And I understand you're saying set that aside for a minute, just look at manufacture.
Exactly.
But it becomes a nullity, again, to say a child can manufacture a firearm but not be in possession of a firearm. That's already unlawful under the Act. And so if you're saying why wouldn't they have specifically said a child could not manufacture, as they did with other categories of prohibited persons under Section 6105, I think the issue is because they said broadly minors can't possess. And then they set forth the exemptions when they could possess. So it is something that the General Assembly has considered, at what point can a minor possess a firearm? And this comes back to that circular nature that we're talking about, where in order to possess something, you have to be able to acquire it in the first place. And that's something else that the Uniform Firearms Act governs, is at what point minors can acquire firearms. And I think that shows that the General Assembly is intending to delineate who is eligible for this process, that they have considered this process. This isn't out of left field. This isn't the first time that the General Assembly's thought about this. And the ownership or possession, for that to be meaningful in any way, and I want to turn back to Ortiz, and I understand Justice.
Before you go to Ortiz, focusing on the words of the statute, could I ask you, the 6120 references ammunition or ammunition components, but it only mentions firearms and not firearms components. Are we not to attribute significance to that distinction?
I don't think you can, because I heard this described as the belt and suspenders approach, where when they said ammunition and then ammunition components, that if you're talking about regulation in any manner, it's going to imbibe, it's going to cover both ammunition and ammunition components. And likewise, the regulation of firearms in any manner would necessarily cover not just firearms, but also firearms components. And I know you're trying to hold me back from getting to Ortiz, but this is one of the reasons that Ortiz is...
I'm not trying to hold you back from anything. I'm just, before you jump to interpreting case law, I just wanted to ask you a statutory text question. But, sorry, go ahead.
Well, and that is a interesting distinction, but I don't think a dispositive distinction. And what I mean by that is, for firearm, if you were to take the alternative construction and say firearm components can be regulated, but so forget the discount the in any manner language. It's only completed firearms, things that meet the definition of a firearm, that can be regulated, can't be regulated rather, but the firearms components can still be regulated. We start to get to an absurd result, because quickly what you'll find is that there's all manner of things that would still fit the definition of a firearm in the Uniform Firearms Act, but not be usable as firearms.
They're, like ammunition components, I guess you could be talking about like powder, right? Musketry. Shell cases. Yeah, okay, but firearm components, the receivers, these unfinished aspects, why shouldn't we consider that the legislature had those things in mind and decided to leave them out, such that a municipality could pick up and legislate it, a home rule municipality could pick up and legislate in that area?
Because it would lead to the very harm that Ortiz was concerned about. And Ortiz said the regulation of firearms is constitutionally protected, therefore the appropriate place to have that debate is in the General Assembly. And if you were to adopt this alternative...
You still have your constitutional challenge, subject to this second argument here, but...
We do, but I think that's one of the things that Ortiz is trying to avoid, a locality or a municipality saying, well, we can ban a barrel. We can ban your barrels because you can still have the firearm. It's still readily convertible. It still meets the definition of a firearm. So we're not banning the firearm. You're allowed to have the firearm. You just can't have a barrel, or you can't load the firearm.
Well, but that's so. The definition of firearm is a complicated one, because the way the statute is written, it relies on the definition basically that the ATF assigns to whatever a firearm is. And when I was on the Commonwealth Court, I had a case dealing with the so-called ghost guns and these polymer 80 kits, these 80% receivers. And one of the issues of that was that the state police adopted a new policy to expand the definition of firearm to include so-called partially manufactured receivers. And the court issued an injunction basically saying, look, you can't define what a partially manufactured receiver is, therefore people don't have notice, they don't know what is and is not a firearm under your new definition, and you've traditionally followed the ATF. Now, the feds have changed the definition of firearm. They've expanded the definition to include certain partially, what used to be called partially manufactured, these 80% kits, and it was subject to a recent challenge in the United States Supreme Court. the Bondi versus Vanderstock decision seemed to let that go, and they're going to let it kind of flow. But you would agree that under that rubric from the Supreme Court, at some point in time, a firearm component becomes a, quote, firearm, close quote, for purposes of regulation on the federal level and under the UFA, correct?
I would agree with that, and I think that this sort of broad history and getting into the federal history of the
Well, no,
definition of a firearm.
I'm into the federal history because it's what we follow in the state. So to Justice Weck's point, even though a block of wood could be turned into a gun, the United States Supreme Court would not say that a block of wood is a firearm, right?
That is correct.
So let's now take the 80% receiver kits, the polymer 80s and the like. As I read Bondi, that very well may be a firearm now, such that it is subject to UFA regulation and has to be serialized. Is that a fair reading of Bondi?
I think that's a fair reading, and to this point, I want to nod to the concerns Justice Doherty was eliciting, which is, what about 12-year-olds getting 3D printers, or everybody in this courtroom getting 3D printers?
Well, nobody's going to say a 3D printer is a firearm, or is going to be a firearm, right? Nobody's going to say that.
Well, where I wanted to go with this is the idea that when in 2021, when this ordinance was passed and this litigation started, we were operating under a somewhat different set of rules in terms of the definition of what constituted a firearm at that point.
Right.
And so to that extent, to the extent that the city was concerned with the polymer 80s that you're discussing and their widespread prevalence and the ability for people to unlawfully make firearms, persons not to possess, etc., make firearms with them, to a large extent, that concern has already been remedied by the federal government. And so you can preserve the integrity of the Uniform Firearms Act here, preserve the integrity of preemption.
My point for saying that is your point. The point is, depending on where a component, a block of wood, crosses the line into firearm would trigger the UFA, right?
That is correct.
So you would have to concede then, prior to that point, meaning the city could regulate the block of wood.
I think they cannot regulate it if they're doing so with the intention to regulate a firearm, and that's cutting to the core of the argument.
I'm not going to get into their heads as to what they intend or they don't intend. I'm going to look at the language of the ordinance. But you would agree that at least from a UFA perspective, the city could exercise its police powers to pass an ordinance that regulates something that is not a firearm.
Absolutely.
Okay.
I would agree with that.
So now we're just talking about lines. We're just talking about where is the line between what is a firearm and what is not yet a firearm.
And I think everyone's in agreement, because the city's position on this point, because the city that we're talking about lines, because the city's position is we can regulate right up to that very edge, and even if that edge shifts at some point, we can regulate to wherever it shifts to, and it's almost like I've got a 4-year-old at home and a 2-year-old at home. It's like the little kids, no, I'm not touching you type argument. And I think that's essentially what we're seeing from the city right now, is they think they can get right up to that. And where I think this is different than an ordinance that just would prohibit possession of a 2x4 block of wood is this ordinance says you can't have a 2x4 block of wood if you start working on it to make a gun.
Well, there's no question this ordinance specifically regulates the manufacture of firearms. I mean, it says that. I'm just trying to figure out if for some reason, if the court would decide that crosses the line, that you can't regulate firearms, you could acknowledge, though, that they could regulate something short of the Bondi line, whatever that happens to be, how the litigation develops there. And I just wonder, should we take a similar approach in this case and say, we're not going to say, we're going to wait to see how this is enforced, and kind of to see whether the city does truly hit what meets the federal definition and thereby the state definition of firearms.
I think that, to respond to your question, this comes back to the entire field preemption debate, because if the field of firearms is preempted, then what we're talking about is really just explicit preemption. You're saying...
But if whatever some legislators may have intended
Doesn't matter.
If they didn't preempt the field, if we're dealing with express preemption, then we really do have to drill down and parse this language, right?
If they did not preempt the field, and if you were to find that the field of firearms is not preempted, then we have to get narrower and ask, in response to your question,
The express preemption.
does the protection for ownership and protection implicitly protect the making of firearms? And I think that the answer to that is yes.
Or expressly. You said implicitly.
I'm sorry, expressly.
Not implicitly.
Not implicitly, you're right, and I apologize for my misstatement there. Expressly, through protection for ownership and possession, protect the mode of acquiring firearms. And if the court were to go the alternative direction and say that the ownership and possession of firearms does not in any way protect the methods of acquisition of firearms, then that would not only be contrary to the case law here, but it would also upend and essentially destroy the protections of Section 6120, because once localities could regulate the manner of acquisition of a firearm, then you are going to see all those things that have been tried and struck down over the years starting to come into play.
Counsel, you indicated you'd like to address some of the other Pennsylvania cases. Do you have more to say on that?
For the most part, we can stand on our papers in that respect, other than to say that this is a line of cases that has been relied on here for 30 years since Ortiz. And I did want to point out one distinction which I do think is relevant in Ortiz, and I understand that, as Justice Donahue pointed out, Ortiz didn't drill down the language, but Ortiz did declare that it was preempted not only an ordinance impacting firearms, but an ordinance impacting accessories in that case as well. And so we feel that that goes directly towards the idea that there is field preemption on the subject of firearms, because Ortiz found accessories in that case to also be preempted by Section 6120. Going even further back, and I told you I wouldn't go deep into the case law, and I won't, but I do want to make the point that going even further back, when we looked at the Schenck case, when the Schenck case occurred, there was only protection in Section 6120 for the ownership and possession of firearms, and they still found that the ordinances in the Schenck case were preempted. And thereafter, the General Assembly actually broadened to make sure that they covered other modes by expanding the definitions of Section 6120, the ownership possession.
Schenck was a famous First Amendment case from 100 years ago.
Schneck, that is correct. I'm missing an M, am I not? Thank you for pointing that out to me.
Counsel, can we take a step back? Maybe you can educate me on a point that I'm kind of a little bit confused about. In follow-up to what Mr. Justice Doherty had asked you, I understand we're focused on the language of the statute, but we're not talking about regulating blocks of wood, as Justice Brobson mentioned. You're talking about an ordinance that, in essence, really talks about unfinished frames and receivers, which are component parts to a firearm, right?
Yes, that is correct.
The language I'm kind of concerned about, because you keep talking about we can't regulate, but firearms are regulated under the UFA, are they not?
They are.
In fact, every single manufacturer of weapons, firearms, in the United States of America and importers, whether it's Colt, SIG, Springfield, Kimber, you name it, has a federal licensing requirement, do they not?
That is correct if they are engaged in the business. So that may be a distinction here that's worth calling out or pointing out, which is...
We'll get to that in a second, but one of the regulations which federal licensing requires is a stamp or a serial number on each firearm.
If you're doing it commercially, yes.
But let's talk about the block of wood that Justice Brobson's talking about. So you've got an unfinished frame and receiver that's put together in the gun. You said you represented 4 individuals that want to manufacture their own guns. Are they federal licenses?
No.
So how do they get the serial numbers then to make it lawful?
So it's lawful under the federal laws if you're doing it for personal use. The serialization is only...
You couldn't put together your own weapon without a serial number on it for personal use?
You may under federal law.
Okay. What section of the federal law is that you're quoting?
So where we're looking, and I can provide you a letter on this, but broadly speaking, we're looking at 922 and 923, 18 U.S.C. 922 and 923, which would govern the manufacturing processes. I don't know that I'm going to be able to provide you a section that says you can do this, because as of course you're well aware, law largely defines what you cannot do.
I'm worried about legitimizing or legalizing something that's otherwise unlawful.
I
think the big issue here, from the law enforcement's perspective and from everybody else's perspective, is these ghost guns are being used dropped at the scene of a crime and there's no way to trace them back. The whole purpose of the serial number is to be able to trace the manufacturer to the buyer. We can get into the reasons for that later, but in this particular case, at which point do they become lawful, and how does the government, law enforcement, how do you enforce that if it's for personal use and you have no serial number on these stamped on an unfinished frame of receiver that identifies the manufacturer?
So the Vanderstock case that we discussed briefly earlier,
That's the 80% kit.
the 80% case, that would lay out, I believe, and I can go back and, as I said, I'd be happy to provide the court a letter on this, but it would lay out the idea that individuals for personal use don't have to serialize firearms that they make. And that remains true under federal law. It remains true under Pennsylvania law. And we talked a little bit about this in our briefing, that there was a proud history in Pennsylvania and in Philadelphia specifically of people being able to make their own firearms. And the federal requirements didn't come around until 1968 to even require manufacturers to begin serialization. Now, I understand all of the reasons and all of the logic on why serial numbers are important on commercially made firearms, but it remains true under Pennsylvania law and federal law that today, if you're manufacturing for your own use, for yourself as a hobbyist, there is no requirement under Pennsylvania or federal law to serialize a firearm.
But Pennsylvania could have a law that says you have to serialize your own personally made firearm. I mean, you may try to challenge it under the Second Amendment or something else, but there's nothing preventing the federal government or the state government from passing such a serialization statute.
There's nothing preventing it, and it's been proposed in the General Assembly. So there's been several instances where the General Assembly has considered whether to make that a requirement.
Can I go back just for a quick to the 3D printer? And I know hypotheticals are dangerous, but I'm trying to understand where your lines are in this case. If the concern is 3D printing, could the city, County of Philadelphia, pass an ordinance that limits the use of 3D printers and says specifically, you can use a 3D printer for your own personal use to do X, Y, and Z, and excludes from the list creating a firearm, and says all other use of 3D printers is prohibited?
Can I make the question easier for myself and say that if they prohibited 3D printers broadly, they just said you can't have a 3D printer, I think that would probably be permissible.
But a 3D printer, banning the use of 3D printers to create component parts that are not yet firearms.
At that point, when...
Did you hear what I said? Component parts that are not yet firearms.
And
they don't cross the Vanderstock line, wherever that line is.
Wherever that line is. I don't think that under the regulation of firearms and preemption for regulation in any manner that you can regulate people making components of firearms.
Under that argument, you can't regulate a block of wood.
Well, I agree and disagree with you, Your Honor, which is to say that you can't regulate a block of wood by itself. Or you can I'm getting myself twisted up here. You can regulate a block of wood by itself. You can't regulate the block of wood for the purpose of stopping somebody from using it on a firearm.
Well, see, then you're getting into purpose, and you're getting into intent. I'm trying to stay away from purpose and intent, and I'm trying to figure out what an ordinance can do. Can an ordinance say in the city of Philadelphia, or elsewhere, we're not just talking, this case is not just about the city of Philadelphia, but can a municipality say, you know what, we love our trees, we don't want trees being used to create guns. Any trees harvested in Lycoming County cannot be used for purposes of manufacturing a firearm. And you would say, nope, because that's regulating the ownership of a firearm, even though the target is saving trees from firearms.
To a certain extent, it may be a question for another day, but I think under a broader, if you want me to answer the question, we're looking at the purposes of the Uniform Firearms Act and what they intend to cover.
I'm looking at the words of the Uniform Firearms Act. I'm not looking at the purpose. The words are the best indication of the intent. I'm looking at the words.
Yeah. Well, and this ordinance is the easiest thing to look at to answer that question, because when we start speculating...
This ordinance, I don't think anybody's going to dispute that this ordinance is addressing the manufacture of firearms. I don't think that's... I'm trying to figure out the reach of your argument, because at some point in time, your argument does get a little hard to swallow, particularly in light of Vanderstock, particularly in light of the Polymer 80 case that I had. At some point in time, even the feds believe a component part or potential part that could become a firearm is a firearm.
And I agree with Your Honor that there are things that fall outside the definition of firearms that you would still be regulating firearms if you regulated. Holsters, for example, clearly not a firearm. No one's going to mistake a firearm for a holster. And yet, if the city were to say we can start banning people from having holsters, they would be affecting how people carry firearms, how they possess firearms, how they transport firearms. They would be affecting a whole lot of areas that are specifically preempted and they're not able to legislate in. And so I think that the easiest question is the one before you today, which is to say, with this ordinance, are they intruding into the realm that they're not allowed to legislate in? And I think the answer to that is yes. They're preventing people from making firearms. And so we don't have to look, and when we talk about purpose, and I heard you say I want to look just at the text and not at the purpose, but I think the purpose is important because when I look at all the prior decisions that look at field preemption in the field of firearms and express preemptions, what they're trying to figure out is what was the legislature trying to do here? What was the legislature trying to preempt? And obviously the text is the best indication of that, but if there's questions based on the text, then we look at the purpose of the legislature.
But you would agree that, speaking generally, not just with reference to this, you would agree that there may be, and no doubt are times when they, and we have to think of them as a singular really, the legislature, was trying to do something and just failed to do it. In other words, we could grant, by argument here, we could grant that they, or it, tried to preempt the field, but didn't, and therefore we have to analyze express preemption or not, right? So they didn't put the word manufacture in, for example. So by hypothesis, we have to ask the question here, one of the questions we have to ask is whether manufacture is subsumed within ownership and possession, right?
That is one of the questions that has to be answered in this case. And as you, I think, pointed out previously, that question becomes more important if you were to decide that field preemption doesn't apply.
And in turn, then the question of whether that's defeated by the words carried or transported at the end of the subsection.
Which, again, follow immediately after ammunition or ammunition components.
But you would agree that we have never actually interpreted the words of this statute.
You've certainly never drilled it down the way you're drilling down on it today.
We have never interpreted the words of the statute. We've issued opinions that broadly proclaim what the intent of the legislature was without doing the predicate task that we do in determining intent, which is looking at the words of the statute.
That is true, but I also want to point out that in your other, outside of the context of firearms, in your other field preemption decisions, you've gone beyond the words of the statute and looked at the intent of the legislature.
We weren't faced with this particular kind of a circumstance.
You were not.
Yeah.
Okay, Mr. Ambler, you have, oh, sure.
Thank you for the question. I've seen other instances where the courts ruled in a certain way, and the court discussed this, I think, in the last argument section here in Philadelphia, where they said the legislature responded very quickly. Within 30 days, there was new legislation to address something that they either thought we got right or something that they thought we got wrong. Here, Ortiz has been the law of the land for 30 years, and we've seen multiple bills proposed that purport to remove preemption and remove the field of firearms preemption. Those bills haven't passed. And so I think that is, it's not as good as the text that's before you, but that is indicative that the legislature understands there to be field preemption.
Counsel, would you agree that municipalities, cities, et cetera, could legislate to enhance the intent of this section?
I think that when there is field preemption, the only local legislation that would be in any way, shape, or form allowable to exist would be things that merely mirror what the state statutes already have. And if it's merely a mirror image, then, as Weber says, it fades into innocuous destitute.
Any other questions? All right, thank you very much.
How about his waiver of the constitutional issue?
I would be happy to answer any questions that you have on that. Other than that, I'm happy to stand on my papers for that.
Can I just get a clarification? If I understand, because there were some removal issues going on here, as I understand it, your client's position is simply you're asserting a state constitutional claim, but you're saying that you're not asking for an expanded right beyond what the Second Amendment provides. And in other words, you're arguing it's coterminous protections with the Second Amendment. You're not arguing any gray.
That's right. We're not asking for a departure.
And under our case law, doesn't that mean that what you have is a federal claim?
No, I think that there's case law that, and we cite this case law throughout our papers, that says that's the default. The federal claim is essentially a floor, but it can be supplied through the state constitution.
You don't have a federal claim. You're specifically
We disclaim.
disavowing any Second Amendment issue in this case.
We did.
So what you're arguing is the Pennsylvania Constitution and the state constitution provide the same rights.
Correct.
And under our case law, doesn't that mean that what you are doing is asserting a federal right? I don't have any doubt. I mean, I like the idea that somebody would come to the court and say, I'm relying only on the Pennsylvania Constitution. Here are my arguments in favor of the Pennsylvania Constitution. It's not what you're doing. You're saying the Pennsylvania Constitution and the federal Constitution are coterminous. Under our case law, doesn't that mean that what you have is a federal constitutional claim?
I don't think so. I think that when you look at the case law, what they say is you can use the state constitution as the vehicle and you can still address federal case law, but it's not a federal constitutional claim at that point.
Because we can't go below the federal
You
floor.
can't go below the federal floor.
So you have a Second Amendment claim. You're just not asserting it.
Correct. Through the vehicle that is the Pennsylvania Constitution.
And when put to our courts in that context, isn't it our history to say what you have is a federal claim?
I may have to provide, Your Honor, a letter on that to specifically, it's not a question I've looked at to answer that.
Isn't that inherent in all of our case law when we deal with situations where somebody says, the Second Amendment and the Pennsylvania Constitution are called into question in this case, and then the argument is based upon federal law?
The argument is based...
Then our courts have said, you have a federal claim. You have not advanced an argument supporting a state constitutional claim. It's what I'm understanding your argument to be is, you want us to follow federal law, including the protocol of looking at the history and what was in effect at the time, and use that to interpret the Pennsylvania Constitution. That's not how we interpret the Pennsylvania Constitution.
Our argument is that the Pennsylvania Constitution can't fall below the federal Constitution.
That's a given. That's why I think what you have is a Second Amendment claim.
And maybe it's a distinction without a difference, Your Honor. I think it's the second part where you're saying, therefore you have a federal claim, that I'm less sure of. Certainly your cases have analyzed the federal claims, but does that make it a federal claim at that point? And maybe, as I said, this is a distinction without difference, but I don't think that makes it a federal claim at that point. I think that the federal case law is relevant to assessing what the floor is, which we know would be a minimum floor under the Pennsylvania Constitution.
All right, I think you've answered all of our questions now, Mr. Ambler. Thank you very much. Well done. Let's hear from Ms. McNaughton. Now, just because the appellant took an hour does not mean you need to take an hour, Ms. McGraw. Of course, we'll give you all the time that you need.
I think that's more in the court's hands than mine. Thank you so much. So, may it please the court, I'm Jennifer McNaughton on behalf of the City of Philadelphia. I was planning to address why 6120 is not field preemption and then to go on to discussing this particular ordinance.
Would you pull the microphone closer, please?
Is that better?
A little higher there. Yeah. Thank you.
Okay. First, I'd just like to correct or respond to something that counsel said about Ortiz. So Ortiz was saying that that decision implicated firearm parts or accessories. That's not mentioned anywhere in Ortiz. The Ortiz decision only pertained to these Philadelphia and Pittsburgh ordinances that were banning assault weapons. And I even went back to the Commonwealth Court decision. It doesn't say anything about any other portions of that ordinance. So we don't have the court's final word on accessories or components yet. We also don't have the court's final word on field preemption, as the question's reflected here. And we have to look at the words of the statute on that question. And here, the field preemption, it's not expressed in the statute. It doesn't say the word field. Neither is it implied in the text or in the structure of the UFA. Now, if you're looking at the text of Section 6120, if it were really field preemption, a lot of the language in that section would be superfluous. Now, field preemption is a broad concept. It's broad preemption. But Section 6120, it's specific. It lists specific activities that cities can't regulate. It lists the specific items that are covered, the firearms, ammunition, et cetera. And it includes those two lawfulness qualifiers. So, and maybe to hopefully clear up some confusion there, we can't regulate a lawful ownership of guns, and we can't regulate if the person who lawfully owns the gun, say somebody who has a license, carries it for an unlawful purpose, say robbing a bank. We accept that. But the fact that there are specifics listed in this statute, this preemption clause, indicates that that is what the General Assembly intended to preempt.
But if, counsel, if you, fair enough, but if you manufacture or acquire one of these kits, and you're legislating in the area, how are you not in any manner regulating the lawful ownership or possession?
Well, there's two responses to that. So first of all, manufacturing is not included in the statute. So if we're not in the world of field preemption, we're legislating outside of what's preempted. Secondly, we're not regulating things that are firearms. And to be clear about what this ordinance does, it's keyed off of the UFA's own definition of firearms, and it is getting at things that are not yet complete enough to meet that definition. So if the 80% rule is what's adopted, and that's clarified through regulation, we're up to the line, as counsel said, but we explicitly said our ordinance is not crossing that line to regulate things that actually are complete enough to be firearms.
Just to follow up briefly, I know what what your counsel was trying to do here. I think we can see that. The question is whether in regulating in some manner the manufacture of one of these ghost guns, you have in any manner regulated the lawful ownership or possession of a firearm. So I mean, does it, in the course of this process of converting one of these kits, have you in fact come to own or possess a firearm?
The ordinance switches off at the point when it becomes a firearm. And the ordinance also wouldn't apply to, say, a ghost gun that was built outside of the city and transported in. The completed product is not regulated. We're hands off at that point. It only regulates the processes, the tools, the kits, the parts, up to the point when it becomes a firearm under the UFA's own definition.
I don't know how you say that. Your ordinance says no person unless licensed to manufacture firearms under federal law shall use a 3D printer to create any firearm. If they do it, they've created, in violating the statute, they create a firearm, not create a glob of plastic, not create a piece of wood. this ordinance prohibits the manufacturing of firearms.
So for the 80% kits, it's probably an easier question. 'Cause
No, let's talk about the part that I'm just talking
so
about.
for the 3D printing.
Yeah, 1A says, in Philadelphia, you cannot use a 3D printer to create a firearm.
Right, so the process of manufacturing is not covered in the UFA. And then as far as.
Well, manufacturing is covered in the UFA, who may and may not manufacture.
Right, as far as licensed manufacturers, or I may be getting off track, under 6120.
6105.
Okay, so
6105 specifically talks about who may and may not manufacture a firearm.
Sure.
And you now passed an ordinance that says no one may manufacture a firearm with a 3D printer unless they have a federal license.
Right, but the thing is that we're using the definition of firearm in the UFA because we don't want to impinge on that. So.
Well, but you said firearm, so you can't create a firearm with a 3D printer, period. So I have a 3D printer. I do whatever a 3D printer does, and lo and behold, I have a firearm. I literally have a firearm now in my possession and in my ownership. I have violated the ordinance. That's not a part short of a firearm. That's a firearm.
Right, it's the process though that's regulated here.
No, it's the completion of it, the creation of it. It's
Right.
not. You're not just regulating the process of it. You're relating the end result. Just having a 3D printer isn't a violation of the ordinance. Creating a firearm with a 3D printer is a violation of the ordinance. So for you to prove a violation of the ordinance, you need to have a completed, regulated firearm.
Right, well, that's the purpose of the ordinance, is to prevent people from creating these things. But we tried to draw the line so that we weren't.
Well, where's the line?
Right, the line is where the General Assembly said it. In the definition of firearm, it has to be something that can be readily converted to expel a projectile.
And your ordinance regulates a firearm, the creation of it, the existence of it. It doesn't. I mean, that's what I'm trying to figure out. I mean, I agree with you under Bondi and Vandergriff and the way the firearm definition is changing. I could see local municipalities being able to regulate up to a point. Even the United States Supreme Court has said, we're not touching this right now. We're going to wait to see where the regulation point is. But you say you'd go up to the line. I'm not sure where you're going up to the line. Use a 3D dimensional printer to create any firearm. To prove a violation of that ordinance, you would have to prove the existence of a firearm, not some line before it. Do you understand what I'm asking?
I do. That almost sounds like an as-applied challenge to the ordinance if we start enforcing it. It hasn't been enforced yet.
But you have the word fire. You don't say. Let me say it this way. If you said use a 3D printer to create something short of a firearm, then I could understand your line. I could say, yeah, you're drawing the line short of a firearm. But your ordinance doesn't. Your ordinance goes all the way to the line. It says firearm.
Well, that sounds like the as-applied challenge, which isn't what we're dealing with here.
Well, what would you regulate under what would be a violation of 1A that would not yield a firearm?
So, again, I think this is the 3D printing aspect isn't necessarily the focus of the ordinance, but the idea is that we are trying to stop the process before it starts, before a firearm comes into existence.
Well, then you would just bar 3D printers.
Yeah, why wouldn't you just say, well, you're not allowed to own a 3D printer capable of making a firearm?
Section
6120 doesn't say we can't do that.
Right, but that's not what your ordinance says.
No.
The ordinance could, to the chief's point, your ordinance could say, in fact, I like that phraseology. You cannot, in the city of Philadelphia, you cannot own a 3D printer capable of creating a firearm without a license by the city of Philadelphia. That's a completely different ordinance than what you drafted.
It is. And again, 6120
Now, that wasn't an
doesn't get to that.
advisory opinion that we would approve of the ordinance, just so you know.
No, I understand.
It's just a hypothetical question.
Right. No, and the intent here, or the attempt here, was to try to stay outside of preemption and still.
If you were doing that, you wouldn't have used the word firearm, or you would have qualified it as not yet a firearm. That's how you stay outside the line of
Counsel-
regulating a firearm.
Counsel, along those lines, if your subsection A said use a three-dimensional printer to create any piece or part or attachment to a firearm, doesn't that get you the same end goal?
Pieces or parts are not firearms under the UFA.
And that's what I'm saying. If you didn't use the phrase create any firearm and instead said create any piece or part or attachment to a firearm.
I think that would have accomplished the same purpose, that we want to stop the process before it gets to the point where we're preempted.
What significance do you attach to the inclusion of the phrase when carried or transported for purposes not prohibited in the statute?
Right, so my understanding of that phrase is that, and these two lawfulness qualifiers, by the way, are clearly indicative that this is not field preemption, because you don't need those if we're preempting everything firearms. But the first lawfulness qualifier deals with lawful ownership possession, so meaning, do you have a license to carry? Are you compliant? You're not a felon. When carried or transported for purposes, I understand that phrase to mean you can't take your lawfully owned licensed firearm and go rob a bank with it. So it's the purpose of the carry or transport that is subject to that second lawfulness qualifier.
Say that again?
So we have two qualifiers here. The first one says lawfully owned, possessed, carried. That means you are licensed, you are not a felon, under state law you are able to carry a firearm. The second one says when carried for purposes not prohibited by the laws of the Commonwealth. So if you take your legally owned licensed firearm and go rob somebody with it, you are carrying that firearm for an unlawful purpose.
Okay, what about a firearm that's in somebody's desk drawer locked up? Is that capable of being regulated by the city? Or put a different way, a firearm sitting in someone's home in a desk drawer that is not locked. Right. Can you regulate that?
If we're focusing on that latter phrase, that's talking about the carry and transport. So it's not getting at, there's no lawful or unlawful purpose to having it in your desk drawer.
So you're of the opinion that it means the regulation cannot regulate firearms when being carried or transported.
Right. That's one of the qualifiers there, that when it carried or transported for purposes that are not unlawful. But that qualifier indicates an intent to allow the city to legislate things that are already unlawful. So consistency with state law.
That's different than the carried or transported.
I'm sorry?
That's different than the phrase when carried or transported.
I think that point encompasses everything. So the possession, ownership, transportation, just the fact that there's those two qualifiers there indicate that there was an intent to allow harmonious local legislation of the things that are listed in the statute. That means this isn't field preemption, because what field preemption is we can't even legislate something that is consistent. We're just not allowed in the area.
Maybe you could explain to me how you think the qualifier when carried or transported impacts the issue before us, which is the manufacturer.
Well, it's not directly applicable to manufacture, because manufacture is not carry or transport.
That's true. Okay, that's a different issue. Manufacturer is not mentioned in the series of regulated conduct. But if we read carried or transported to modify everything that precedes it, how does that impact the manufacture of the firearm? I mean, the firearm is not being carried or transported in the manufacturing process.
I don't think it does. I don't think it has anything to say about manufacture one way or the other, because, as Your Honor said, it's not a transport or carry process.
But let's assume, for the sake of this discussion, that your opposing counsel is correct, that manufacture is subsumed in the concept of ownership and possession. Then you add the qualifier, when carried or transported. Does that preclude the application of this to manufacture, since being carried or transported is not inherent in the manufacturing process?
I guess I'm having trouble understanding how the two would interact because, as Your Honor said, carry or transport it's not something you do while manufacturing.
Well, that would be the answer, wouldn't it?
I think so.
Because the manufacturer of the firearm is not in the carrying or transport of it.
That's correct.
If I were using a 3D printer and assuming I could create a full firearm in a 3D printer, how would I get it out of the 3D printer and put it in my gun safe?
And put it, I'm sorry, I couldn't hear
And
that.
put it in my gun safe? How would I get it from the 3D printer in my basement to my gun safe in my bedroom?
I see what Your Honor's saying. I think there's a difference between picking up and carrying versus
Carrying.
a term of art, carrying a firearm, which is
It's not transporting either? I'm not transporting it from one part of my house to another?
I don't know that that's
Let me ask you,
part of the legislative intent.
let me ask you a different question. What are the ways a person can come into possession of a firearm?
To come into possession?
How does a person come into possession or ownership of a firearm?
Well, clearly the General Assembly was considering transfer as the way that
Okay,
happens.
that's
because-
one.
Yeah, right.
So
Because,
somebody transfers me their gun.
yeah. I
Okay,
mean,
what's another way?
manufacturing is another way to come into possession, for that
So that's
possession.
a manner of coming into possession of a firearm is manufacturing it.
Right. But
That's
it's,
in any manner language kicks in then, right?
so the in any manner language, I think that captures more the fact that there's a lot of different ways that municipalities can regulate. Like we can regulate by directly saying you can't do this, but we can also regulate indirectly. So by taxation is the prime example. Taxation influences behavior. And I think that language in Section 6120, it's not some sort of hidden field preemption language as GOA is arguing. It's getting at the fact that these things that are listed in the statute, we can't regulate them directly or indirectly.
Well, if I can come into possession of a firearm by manufacturing it, by accepting it as a transfer, a gift, by purchasing it from a licensed dealer, and let's say those are the only three ways that I can do it, would a manner of regulating possession be one that cuts one of those off? Would that be a manner of regulating possession if I eliminated one way of possessing?
I think if there were an extreme example that say we prohibited people from buying firearms, that would be affecting.
Well, that's one of the three pillars, right?
Right, it's affecting acquisition, so
you
it's
couldn't
burdening possession, yeah.
You couldn't knock that pillar off. You couldn't pass an ordinance that bars coming into possession or ownership by way of purchasing. But you could knock off one of the other pillars. You can't come into possession or ownership by manufacturing. That's a pillar you can knock off.
In the express words of the statute, no, that's just not covered. What's covered is
Because
transfer.
manufacturing is not mentioned.
Right, manufacturing's not
But
mentioned.
getting back to Justice, pardon me for interrupting you, getting back to Justice Brobson's question about 10 minutes ago, once it's manufactured, even under the words of your ordinance, it has to exist. And once it exists, you have possession or ownership of it. So doesn't that, in essence, render the omission of manufacturing unimportant, or maybe that's not dispositive, because once you've manufactured it in a 3D printer, it exists.
Right, I think that's what I was trying to get at, is that once the gun, it exists, it is possessed, that's when Section 6120 kicks in. But it's interesting, the General Assembly used the word transfer because at that time, when 6120 was enacted, ghost guns just weren't a thing back then. For 3D printers were certainly not a thing back then. So the General Assembly just wasn't thinking about people buying these kits or 3D printing something.
Well, of course not. I mean, that's the point. But
Right.
the question is not whether they were thinking about ghost guns, and the question is not even whether they should be doing something about ghost guns, right? That's a completely different question, and it's certainly something we recognized in Ortiz, that the General Assembly could act to deal with these new technologies and things like that. But the question is, what does the ordinance? We don't construe an ordinance by virtue of the current times in as much as we apply the current times to the ordinance. And you're just identifying one new mode of manufacture. Now, it's a mode of manufacture that can escape a lot of safety things that we like in our society and our community. But going back to my point, 3 ways: transfer, purchase, manufacture. All 3 ways you recognize are ways to come into ownership or possession of a firearm, correct?
That's correct. But
And your ordinance knocks out one of those ways.
so to clarify a couple of points. To clarify, the ordinance does not knock out all manufacturing. It's very tailored to this homemade firearms niche method of manufacturing, and it exempts the federally licensed manufacturers. So if like Smith & Wesson wants to open in Philadelphia, the ordinance has nothing to say about that. It doesn't knock out all manufacturing because we're specifically
It knocks
saying
out personal manufacturing of your personal weapon, which you understand is permitted under federal and state law.
it's a pretty niche method of coming into possession of a firearm.
Okay, so, but it's still a way. It's still a manner.
It is a way, but these plaintiffs have never alleged that their ability to possess or come into possession of firearms generally has been burdened. They've only alleged that this specific niche method of doing so is now unavailable to
Well,
them.
but that's like saying you could pass an ordinance that bars a certain firearm. Well, we haven't said you can't come into possession of all firearms. We're just going to outlaw 10-millimeter pistols.
Again,
So we're not burdening your ability to own a firearm. We're just burdening your niche ability to own this particular firearm.
well, that's more directly involving ownership, like the Ortiz case with a gun ban. This is, again, the Section 6120 doesn't say acquire, it says transfer.
Once you use, in the words of your ordinance, 3D printer or any additive manufacturing process, or you convert an unfinished, et cetera, is that firearm, because you're using the word firearm, is that firearm not owned or possessed?
Right, but it's
I mean,
not
it
the...
doesn't exist in the state of nature. It's owned or possessed, isn't it?
Sure, but the ordinance targets the process of taking it from this uncompleted state to a completed state. It doesn't purport to regulate completed ghost guns at all.
But how do you separate those two? It's hard for me to understand how you can prevent the creation of a firearm with a 3D printer, but not affect the actual holding and ownership of it, possession of it once it's completed, because you're contemplating it will become a completed firearm, right?
Well, this is true, but again, the ordinance doesn't try to regulate the completed gun. So somebody wants to buy a ghost gun at a gun show and bring it into Philadelphia. The ordinance has nothing to say about that. It's pulled back from that point, and it's limited to the manufacturing process of something that is not yet a firearm.
So if a son took a piece of wood and carved it and made a very long stop, and another son took a piece of metal and made a very long
Barrel?
and gave it to their grandfather, is that permitted under your statute?
Did your sons do that?
I am not sure that I would have to drill down in the definition of additive manufacturing, because I just don't know if the block of wood satisfies that. But I think the intent
Well,
is there.
at some point in time, the unfinished block of wood would be considered an unfinished frame.
Right. And that's what we're trying to get at, is that we want to stop the process before it gets to the point where it becomes a firearm. So.
Come together, boom, complete firearm. Permissible or not under your statute?
I think the difficulty here is that this is an area of evolving regulations, and so I don't know to what extent the block of wood would be considered if it's at the 80% line under. Yeah, it's possible, but again, I don't know exactly where in that hypothetical if that thing that you're describing is going to cross the line. To be considered
Well, it doesn't
a firearm
matter.
under
It doesn't
state law.
matter. It doesn't matter where it crosses the line, because you say the line is before it becomes a firearm. So it doesn't matter. At any point in time before it, you can actually, at least according to your claim on the ordinance, at any point in time before the gun can expel a projectile under force, that would be prohibited under the ordinance.
Right, before the point where it can be readily converted.
Right.
To expel the projectile, that's correct.
So in Justice Mundy's hypothetical, what she is saying is it would be illegal under this ordinance.
Potentially, right, if we're talking about things that are, right, from the block of
So
wood
it's
up
broader
to
than ghost guns, it's broader than 80% receivers, it's impacting all personal manufacture of firearms.
Wait, I thought it was just 3D printers.
Oh, no, it's 3D printers and it's these kits.
And
But
the
it's
kits,
the,
so
it's
you
the
would-
kits, but not the ones that are past, I'm using 80% as the shorthand because that's consistent with.
Well,
what
it's
the
not just
regulation is
kits.
going, but-
It says convert an unfinished frame or receiver into a finished firearm.
Right, it's,
An unfinished frame or receiver could be the block of wood. It could be, you don't say 80% receivers here, which again is a term of art in the industry right now. Your ordinance bars the manufacture of all firearms. It may not bar the original carving of the wood, but the minute it gets to an undefined point that you're saying exists prior to becoming firearms, your ordinance kicks in.
no, the ordinance kicks in from the block of wood up to the 80%.
Okay, so it's even illegal to put a knife into a block of wood.
I mean, if that's I think it would be all difficult for our police to enforce that.
Well,
But
that's a lot of comfort.
Right. But that's, again, this section 6120 doesn't speak to manufacturing.
It does. 6105 speaks to manufacturing, specifically
Right.
provides who may and may not manufacture a firearm.
Which is indicative of the fact that the General Assembly knows that manufacturing is something different than ownership, possession, transfer, transportation.
Well, it's
which
also
are the words.
it's also indicative of the fact that the General Assembly is regulated in the field of firearm manufacture already.
They've regulated the subject matter of firearms and firearm manufacturing, but to go the extra step and to say this is field preemption, that requires a lot more than what the statute is providing us. Again, this court's case law has said over and over again, an intent to preempt the field must be crystal clear.
Well, if I have an ordinance or if I have a state law that says only people above the age of 22 years old may manufacture and sell their own Italian ice. Can the Philadelphia pass an ordinance that says only people 30 and older can do it? We know the state says you can do it if you're younger than 30, but we're going to say 30 and older. Would that be permissible?
I think that would be a conflict preemption analysis.
Okay.
And
So if the statute says certain people are barred from manufacturing firearms, and you pass an ordinance that bars even more, that's not conflict preemption?
That's not the argument that was made here, and so there's been no claim of conflict preemption here. I think we'd have to hash that out in a case where it was actually litigated, but the issue here is field preemption, and this statute doesn't preempt the field. The Italian ice, I don't know that there's any preemption in the Italian ice realm, but it's a separate analysis of preemption. So here we're focused on the text. Here we're focused on what the General Assembly intended. And the bar for showing preemption is high, generally, because of home rule. And this court...
I'm sorry, pardon me, counsel. You concede you have a tougher road to hoe with express preemption than with field preemption. In other words, if you clear the field preemption hurdle, you still have to confront the words of the statute and explain why you're not expressly preempted, which is the bulk of the questioning you've been fielding here.
I think it's the opposite. I think it's an easier row to hoe if this is not field preemption, because then we can look at those express words of the statute and say, this says nothing about manufacturing. So there's the no manufacturing preempted here, and there's also the fact that we're not dealing with firearms, which is the argument that won the day in Commonwealth court, despite them assuming it was field preemption. So, no, I think that ends the case. If we're not field preempted, there's no preemption of regulation of manufacturing, we're done. So, just to get back to what I was trying to emphasize is that preemption generally, it's a high standard to show that local laws are preempted, and recently in Crawford, this court made that very clear. And the types of things that we've been talking about today, this in any manner language, just the fact that the UFA has a lot of regulations of firearms, the structure, the overall structure, those don't overcome that high hurdle. And just to go back to the structure real quick, the Uniform Firearms Act is nothing like those heavily regulated industries that this court felt met the high burden of showing implied field preemption. So things like banking or public utilities, those contain tomes of regulations. There are technical industries. In the case of alcohol, there's actually a state oligopoly that takes up a huge portion of that market and brings it into the hands of the government. There's no state stores for guns. There's no highly technical regulations of guns. There's some, just like we have some regulation of elections in the election code, and that was found not to be field preemption. So there's nothing here that indicates that clear legislative intent to preempt the field, which means we are now in the realm of ordinary preemption. And as we've been discussing, under the ordinary preemption analysis, manufacturing is not covered in the plain language of the statute.
Is it possible, counsel, that the reason we don't see a bureaucracy or a superstructure like we do with mining or the other regulated industries you've talked about, that there's a constitutional right here?
Well,
in other words, we don't see the government creating this bureaucracy for mining or gaming or what have you, because while there's no constitutional right to mine or gaming or do gaming, there's a constitutional right to bear arms.
Well, a lot of local regulation has constitutional implications, and that doesn't necessarily follow that all local regulation is going to be field preempted. And I think a prime example is the Nutter v. Doherty case. So there we are dealing with a constitutional provision that said we must have uniformity in the holding of elections. And that was the argument that Representative Fattah used to say this must preempt the field, because the election code must preempt the field because we have a constitutional provision at stake here. Nonetheless, the court found that wasn't the case. We have regulation that affects things like, the equal protection clauses, anti-discrimination. We are allowed to have our own local fair practices ordinance that gets at discrimination. So the Constitution is everywhere, and state and local governments need to be partners in upholding the Constitution. But that doesn't mean that local governments are now kicked out of that realm entirely.
That's a better argument than extensive federal bureaucracy is indicative of field preemption.
Oh, of federal preemption?
Yeah, of field preemption. You said for us to find field preemption, we need evidence that the state has an extensive bureaucracy, much like the Liquor Control Board and stuff like that. What you've just articulated, I think, is a more persuasive argument.
Okay, well, thank you, Your Honor.
And you can stop there. Don't push your luck.
All right, so I think, I just wanted to emphasize one more thing. We talked about the Bondi case and the potential for federal regulation in the area of ghost guns. I just wanted to emphasize that what the city's trying to do here is fill a regulatory gap. So right now the area is evolving, and I'm sure we're going to get more clarity as it continues to evolve at the federal level and potentially at the state level as well. We're trying to fill the gap in things that are not yet firearms under state law and therefore are not yet regulated under state law. But we can see what's going to happen is that as soon as the feds start getting more aggressive about the 80% kits, that it's going to become 70%, 60%.
There's nothing stopping the state government from getting more aggressive about 80% kits now. With the change in the federal definition, we could see whether it's the state police or someone else start saying there's a new definition of firearm in town. We're going to start citing all these 80% receiver kits at these gun shows and say you're not serialized, and start citing and shutting them down. That could happen tomorrow.
Oh, absolutely, and the city of Philadelphia would welcome that kind of action.
Well, counsel, I have a question. I'm just trying to clarify this. Is your argument, hypothetically, well, not hypothetically, the General Assembly passed the Uniform Firearms Act. Specifically, 6110 creates a concept of felony of the second degree for a possession of a firearm that has a manufacturer number removed or obliterated. Your ordinance is geared toward making sure that manufactured firearms without a serial number are prohibited, at least in the city and county of Philadelphia. Is that what you're saying?
We're
Such
trying-
that it's a regulation in support of 6110 as opposed to a challenge that it's a field preemption, that you're not permitted to enhance locally what the General Assembly has permitted for the Commonwealth?
I think it is not inconsistent with 6110, certainly. It's upholding the same goals as 6110, is that we want firearms to be serialized. I think the difference here is that because of 6120, we know we're preempted once the firearm becomes a gun. So if it's 3D printed, put together, what have you, but doesn't have a serial number, we, at that point, can't regulate it.
Can or cannot?
Well, if it's the lawful ownership, possession, et cetera, the words are right there. We can't
You agree the only people that have to serialize a gun are manufacturers of third-party sales?
Under federal law, it sounds
Federal
like
and state law.
right.
Right.
That sounds like that's the case now.
Right. So
I
you
do
can't
hope that
you can't
changes.
buy a firearm that is serialized and obliterated under 6110. That is illegal.
Right, and the ordinance isn't trying to get at that.
Right.
What it's trying to get at is this process of creating unserialized firearms,
Which is legal.
which, with creating them, yeah,
Yes.
at the moment it is.
Right.
But that's the gap we're trying to fill.
All right, any other questions? Thank you very much, Ms. McNaughton. Thank you both, well argued. Mr. Minner, would you call the next case?
Sandra Khalil versus Mary Jane Follman Richmond Center, representing Ms. Khalil, Mr. Dennis Whitaker.
Your Honor.
In this civil litigation, we address a series of interlocutory orders concerning the withdrawal of appellant's pro bono counsel. In April 2023, the trial court granted counsel's motion to withdraw. A month later, appellant filed a motion for reconsideration of the order granting counsel's withdrawal, which the trial court denied in early June. 1 week later, appellant filed a pro se notice of appeal of the June order. The Superior Court quashed the appeal sua sponte, concluding that the appeal was untimely because appellant did not file her notice of appeal within 30 days of the April order, and deemed the June reconsideration order to be unappealable. We are asked to address whether appellant's appeal of the last in a series of interlocutory collateral orders, including a reconsideration order, is timely, whether a collateral order must be appealed within 30 days, and whether appeals from final orders are governed by different appellant rules than appeals from collateral orders, including an appeal of an order denying reconsideration of the original collateral order. I hope that was largely correct. Please proceed.
Yes, that's actually the order, the issue on which the court granted aliquot, Your Honor. I'm Dennis Whitaker, may it please the court. My colleague Melissa Chapaska is here with me today, and we are representing the appellant in this matter, Sandra Khalil.
And there will not be argument from an appellee in this case.
Yes, the appellee has actually never participated, did not participate in the Superior Court, nor have they participated here. Ms. Khalil came to the court proceeding pro se and in form of pauperis to challenge the order of the Philadelphia Court of Common Pleas, which granted her pro bono counsel's motion to withdraw from further representing her before that court. The record indicates that the withdrawal of pro bono counsel was not mandatory or explicitly justified under Rule of Professional Conduct 1.16, and further was materially adverse to Ms. Khalil's interest in the specific matter in which pro bono counsel was appointed, where it resulted in specific harm to her case and delayed critical progress. The order's not final. It's separable from the merits. It involves a right too important to be denied review, and if review is postponed, the right will be irreparably lost as it is effectively unreviewable. As you pointed out, or as you mentioned, Your Honor,
Well, excuse me, I don't know that I believe it's a collateral order. Why is the right lost? Why can't Ms. Khalil go through her trial pro se, and if she loses, raise the appeal at the end of the trial?
she's already forced to file the appeal on her own after pro bono counsel withdrew, and there's a lot of underlying issues with that, which we may or may not discuss. But she was forced to file the appeal when they withdrew. The record supports that she made extensive efforts on her own to find additional counsel, and the record further supports that pro bono counsel gave no assistance in that regard whatsoever.
I'm not arguing with you about any of those issues. My sole point is I don't believe this is a collateral order because our court has said that orders disqualifying counsel in civil cases are not collateral orders subject to appeal. And my specific question to you was, what is the harm to Ms. Khalil that she can't raise this issue if she loses on appeal?
Number one, trying to answer your question, Your Honor. A lot of time has already passed. Ms. Khalil will be forced to essentially litigate against a lawyer, try to preserve all these issues, and then down the line, notwithstanding the fact that the record already shows that previous pro bono counsel violated both the Philadelphia rule regarding withdrawal, the rules of civil procedure regarding withdrawal, arguably Rule 1.16, which requires that withdrawal be done without materially damaging Ms. Khalil's interests.
Yeah, but counsel, what are Ms. Khalil's interests?
I'm sorry, Your Honor.
What are Ms. Khalil's interests? Because in order to qualify, along the lines of what Justice Mundy was just asking you, in order to qualify as a collateral order, it's got to implicate rights too important to be denied review. What rights does a pro se plaintiff have in a civil case? It's not a criminal case. They can proceed pro se. What right do they have to force an attorney to represent them in a cause of action that may not exist?
Your Honor's correct, there's no civil Gideon in Pennsylvania. However, once this court, the Chief Justice sends out a letter every year, the Rule 6.1 encourages pro bono representation, and Rule 1.16 says when that happens, when you undertake that, there are certain things that you are required to do, one of which is minimize materially adverse effects when you withdraw.
But the rules also impose an obligation upon attorneys for candor of the court. If I'm pro bono counsel and the Chief Justice sends out a letter and says, we want you to represent people on a pro bono basis, and I agree to do it. If I meet with you and I look at your case and I said, I don't think you've got a cause of action, under the rules of professional conduct, I have a duty of candor to the court. What right do you have as a pro se plaintiff to force me to continue to represent you where you don't have a cause of action? That's the right that we're talking about for collateral review, right?
The record doesn't support that there's no cause of action here, number one. And number two, the issue, the way the test is stated is that an important right that has a basis beyond normal, and I'm saying, or what we're arguing here, is that once the court encourages pro bono representation,
Court encourages all kind of things, and you seem to want to invite us to get into a line drawing exercise, telling our lower courts to engage in an inquiry When is this, particular litigant prejudiced enough that we're going to bootstrap her into collateral order status? Why couldn't she follow the rule that has been in place since 68? We have a case from 1968, and then 1980. You don't cite either of these cases. In 1989, in the Sidkoff, Marcus, and Green case, this court made it very, very clear, and I think every justice up here knows it's always been the rule. You file your motion for reconsideration, and at the same time you perfect your appeal, so that if the court doesn't rule on your motion or denies it, you're protected. Why is your client so special that she's not subject to that rule that applies everywhere else in Pennsylvania civil litigation?
Ms. Khalil followed the procedure for appealing to Superior Court that Superior Court had laid out. And in fact, the Cabot case in Superior Court is on all fours with this case. It was a series of collateral orders. That was a discovery matter. But the last order in that case was a denial of reconsideration. And the court said, we do not consider denial of reconsideration to be appealing reconsideration. We consider that to be the terminal order in the series, and that means that you're appealing all the other collateral orders and all the other interlocutory orders in the series.
You see where this Superior Court case law about a series, you see the problems it's getting us into here, because it's monkeying with the 30-day rule, and it forces courts to determine what is the series. First of all, what's a collateral order, which we have to do, which is another layer. But once we're over that hurdle, then what's a series and what's outside the series? Isn't it better to have a bright line rule like our rules contemplate instead of this Superior Court frolic of deciding what a series is?
Well, the problem is there's no bright line rule. The bright line rule regarding appealing or trying to appeal denials of reconsideration is tied to Rule 341, final orders. With regard to collateral or interlocutory orders, 311, appeal as of right, may be filed within 30 days. 312, appeal by permission, may be filed within 30 days.
Well, so interlocutory orders and collateral orders are not the same things.
Actually, if you have a Venn diagram, all collateral orders are a smaller circle inside the larger interlocutory order circle.
Well, that's the whole all oranges are fruit, but not all fruit are oranges.
Yes. Right. It's like all Amish are Mennonites, but not all Mennonites are Amish.
I like the fruit thing better than the Amish and Mennonite thing.
We'll go with that.
But I guess, so look, I mean, the Superior Court didn't quash this case because they made a determination on whether it was a collateral order or not. And I think Justice Weck's point is a good point. Your client, assuming your client did, says that your client relied on this Superior Court decision that to me just seems like an outlier from our actual rules of procedure in terms of the collateral order reconsideration distinction. Let's say we say that. Let's say that case has to go away. That opinion is bunk. If you have the right to appeal a collateral order and you want to appeal it instead of waiting until the end of the case, you must file your appeal within 30 days, full stop. If we say that, should we nonetheless provide your client with some relief because your client relied on a Superior Court decision that we're basically saying was not a good decision?
I don't disagree with that, Your Honor. I think it would be if the court somehow said, well, you can appeal the last order in a series of collateral.
No, I'm saying we don't say that. I'm saying we follow our rules of civil procedure. We say we know what the collateral reconsideration is not a collateral order. Reconsideration is a motion off of a collateral order, and we say the rules say appeal a collateral order. If you want to appeal it and you don't want to wait, you have to file your appeal within 30 days. Full stop. Bright line rule. We're done. You appeal it up, and the Superior Court or the Commonwealth Court can decide whether it's a collateral order or not, and that always happens. But we're saying here, full stop, 30 days. Your client's appeal to the Superior Court was clearly untimely. But we say in this case, should we say in this case, Unfortunately, there's no opposing counsel here. Should we say in this case, but your client reasonably relied on a Superior Court decision that we're now getting rid of, so we're going to send it back to the Superior Court and give you a nunc-pro-tunc collateral appeal?
You'd take that. You'd take that, wouldn't you? You'd accept that, wouldn't you?
Yes, well, I would note also that Judge Fletman's opinion from the Common Pleas Court also cited Cabot. So Judge Fletman... I'm not just, of course he did, because it exists. We're talking about, we didn't take this case, we would probably took this case to basically deal with the Superior Court's decision that appears in conflict with our rules of civil procedure. We would take... You'd take the dub? Yes.
Yeah.
We would take, if you suggested that. If that's what the court did, that would give Ms. Khalil a bite at the apple that she got, that she had Superior Court followed its own case law, that she would have gotten, and the appeal might not have ever come up here. However, I would suggest that the court's view of interlocutory orders isn't necessarily consonant with A, what the practice is, and B, the language of the rules.
But she's got no constitutional or even rule-based right to counsel.
Well,
and Shearer versus Hafer, we rejected this argument in an arguably more critical situation.
Actually, you did not reject this argument. The issue in Shearer was whether or not the person could have a lawyer or other representation. And in fact, when Justice Todd wrote the opinion, she pointed out that this is not solely about representation by counsel. As we pointed out in our brief, in this case, that's all that this is about, is representation by counsel.
Counsel, is it fair to say that the propriety of the withdrawal could be addressed at final judgment at the end of a trial, when an appeal, correct?
Yes, it could.
So if it could, it's not irreparably lost. Therefore, it doesn't meet the definition of a collateral order as per.
Well, I don't think that's correct, Your Honor.
You don't?
Because in Chaluti, that this court decided in January, the test isn't can it be addressed at the end. To Chaluti, the quote is, to satisfy the irreparability prong, the matter must be effectively unreviewable on appeal from final judgment, and that's citing Commonwealth v. Wells, which is a PCRA case.
The operative word is irreparably lost. It's not.
How would that violate, how would what Justice Doherty is asking you violate that Chaluti wording?
I'm sorry, I missed your question.
How is what Justice Doherty is saying to you violate that wording in Chaluti?
It's not irreparably lost, it's effectively lost. Chaluti...
How is it effectively lost?
It's effectively lost because the passage of time...
Well, Chaluti, we specifically said the passage of time doesn't matter. The passage, the expense, whatever expense you have to go through these processes and things like that, that is not a consideration for purposes of whether something is irreparably lost.
If Ms. Khalil was not indigent, I would suggest that might be correct. But the two things that happened here, she was represented by appointed pro bono counsel. The record supports the inference, at least, that they essentially dropped her with no effort whatsoever to assist her in getting other counsel.
Okay, so she goes through the case, she goes through the civil trial, she loses, she appeals to the Superior Court and says, I need a new trial, you need to reverse the judgment because my counsel abandoned me. And the Superior Court goes, you're absolutely right, new trial.
All these things push it down the line. She's operating without counsel, and you're essentially assuming that she will be able to carry forward.
She got to the Pennsylvania Supreme Court.
I'm sorry?
She got to the Pennsylvania Supreme Court.
Well, yes, she did. But you're also saying now she's going to have to go back, try this case by herself, if she could do it, conduct discovery.
Why is she so unique? We've all had many cases with pro se litigants. I mean, there are pro se litigants litigating much more critical things, child custody. Why is your client so special that her claim is irreparably lost when all these other litigants across Pennsylvania who are trying cases pro se in civil context, right now in this city, for example, that their claims are not as special as your client's claim. Remember, in this case, the trial court allowed counsel to withdraw, stayed the case for 120 days so your client could get counsel, and you're coming here now and telling us this was irreparably lost.
Yes. If you look at the record here, counsel withdrew in 2019. Ms. Khalil, it's in the record, spent a fair bit of time, and it's all in the record, trying to get new counsel. It was only when she could not do so that she asked the court to reinstate counsel, because when they withdrew, they didn't withdraw properly. The court did that. Then we ended up with the hearing. The issue isn't the issue isn't that Ms. Khalil is special. The issue is that with pro bono representation, once counsel undertakes that, there's certain obligations that weren't followed through with here.
But counsel was removed after a second time. The counsel withdrew without following the procedure. Therefore, the court turned around and said, no, we'll vacate that, your counsel again. Then that counsel withdrew by order of the court, correct?
Yes, that's the order. That's the order that was attempted to be appealed.
So we have that. Now, where's your issue?
Well, there's two things. She's appealing the order. Number one, I would suggest that we're not to get into the merits here, but the merits also somewhat tie in to why it's important that Ms. Khalil's appeal be allowed to go forward. The argument here is that, well, the argument would be is there's not sufficient evidence in the record to support what the trial court did. If you read Judge Fletman's opinion, she talks about how pro bono counsel testified. Pro bono counsel didn't testify, was never sworn in.
You're arguing the merits of a trial court decision. Let me just put, and we understand your client timely filed a motion for reconsideration, but the fatal problem is she didn't go next door that same day and file the appeal. That's all she had to do, and that's why I keep coming back to this point is your position basically is your client is so special that unlike everybody else in Pennsylvania, she doesn't have to do that other thing. She doesn't have to file that appeal notice when she files her motion for reconsideration. She's more special than Shearer versus Hafer. She's more special than the Sidcup versus Green case. And I just don't follow that reasoning.
There's two different things there. Number one, Shearer v. Hafer, it wasn't an appeal from an order denying reconsideration. As far as appealing the reconsideration order, she followed binding precedent, not on this court, but on the court of common.
We're mixing two different things, though. This "my client is so special" argument is an argument you're making on the merits of whether it's a collateral order, which the Superior Court did not get to.
Right.
Now, you may, if we decided that, which I don't think we took it for that reason, but if we decide that, we're essentially giving your client a nunc-pro-tunc appeal by deciding whether it was a collateral order. But so you probably, except you're answering the question of the justices, stay away from this argument, "my client is so special," because that goes to the merits of whether the claim is irreparably lost for purposes of a collateral order prong. Justice Wechten and I, to a certain extent, are focused on the question that we took, which is, did your client timely appeal to the Superior Court from the order denying letting counsel go, right? And Justice Wecht's point is, if that was a collateral order, which your client takes the position it was, our rules would say you had to Our rules would say that you had to appeal that within 30 days. Your answer to that is yes, but there's this Superior Court decision that says as long as I keep filing motions for reconsideration ad nauseum, I can stage that 30 days out and create this serial collateral order thing. I just want to separate the two. One argument is my client is so special and we should have a rule for collateral orders that makes the withdrawal of counsel irreparable. One is purely, did your client appeal timely?
I want to agree with what you're saying. And I also want to make clear, and maybe when I finish here, I'll just sit down and shut up. But if the result's going to be you'll remand it back to Superior Court to say the appeal was timely under what the law was then, here.
I doubt we're going to do that. I mean, I think the point is, though, at least what I'm suggesting to you is maybe the issue we shouldn't talk about is collateral order. You can make my client a special arguments in the Superior Court if we give you a nunc-pro-tunc appeal. Your appeal was untimely.
It's not that the issue isn't that Ms. Khalil is
Wait,
special.
just a minute, Mr. Ruger.
We're very busy today.
You're very busy.
You know that's loud if I get drowned out.
Go ahead.
The issue isn't, and maybe that's what I'm having problem. The issue isn't that Ms. Khalil is special. The issue is that pro bono representation creates certain additional requirements for attorneys which were not filed here. That's why it's different than Shearer, and that's why it fits in.
Counsel, there's the issue. What was not followed there? The lawyer withdrew inappropriately. Your client filed a motion, and the judge granted it and reinstated. Then that lawyer withdrew through appropriate procedure. That full stop, as Justice Brobson said. Where's this issue that you say you have this right to continue filing motion to reconsider in perpetuity?
No, that's actually not what happened in any of the Superior Court cases. All Cabot says is that where there's a series of interlocutory orders, it's the terminal order that does it, even if the last order is a petition for reconsideration. If you look at Cabot and you look at the Cabot, Jones, McGrogan, and blank on the fourth case. If you look at those cases, none of those involve serial reconsideration orders. One of them involves a motion for trial nunc-pro-tunc. Cabot happens to involve one petition for reconsideration, which the court denied. The appeal was taken for that, and consistent with all its prior cases, the Superior Court said it's the terminal order. That's the one that's appealable, or they're all appealable, but because 311, 312, and 313 all say may be appealed, not must be appealed within 30 days, you can wait to appeal the terminal order, and we don't care if the terminal order is denial of reconsideration, because we're not looking at we're not considering that an appeal of denial of reconsideration. We're considering it an appeal of all the predecessor orders. And I would also point out that Rule 51, make sure I don't miscite the rule, Rule 5105A2 provides an exception for agency denials of reconsideration. It makes those appealable as of right. And now, admittedly, that's limited to the denial of reconsideration, not the merits of the order, but there's an exception right there to the reconsideration orders aren't appealable. It's by statute, but it's an exception nonetheless. So to say that, well, the reconsideration rule's ironclad, it's clearly not. There's already been exceptions to it. And what Superior Court has done here is actually eliminate the need to appeal. Belt and Suspenders says that every time there's an interlocutory order, if you think it's an appeal as of right, maybe you'd better appeal it. Maybe you'd better seek an appeal by permission.
Well, that's not necessarily true for collateral orders.
What's that?
That's not necessarily true for a collateral order. A collateral order may be appealed immediately, but it doesn't have to be appealed
Right,
immediately.
exactly. Exactly. But what I'm saying is, it says it may be appealed, and you don't waive it. But belt and suspenders says, maybe I should appeal this. The Superior Court eliminates that completely and says you can
No, if your
wait till
client
the
would
end.
have appealed it, if your client would have appealed it within 30 days, we wouldn't be here.
Counsel, can I ask you about, it's Justice Donahue. I don't know where that voice comes from, but
Yeah.
let me ask you a question about our rules. Our rules regarding what happens when a motion for reconsideration is filed, that rule being you can file it, but you still have to take your appeal within the appeal period, correct?
That's 1701.
That rule does not now apply to collateral orders, correct?
That's correct.
So if we amended our rules of procedure to make clear that in the context of collateral orders, from which a motion for consideration could be filed, I mean, a discovery motion or any unprivileged or things of that nature, if we make our rules clear that if you want to file a motion for reconsideration, just like with every other appeal, you still have to perfect your appeal, we'd be okay.
Yes.
Okay. Or if you don't file your appeal, but you still file your motion for reconsideration, you still have the ability with a collateral order to appeal it at the end of the case.
Yes.
Okay, so, I mean, really, our problem here is really a failure of our rules to make clear what happens with collateral orders, to sync it with what happens with motions for reconsideration that are filed in any other context. You could file it, but you have to file your appeal.
Yes. I think what underlies some of the confusion here is that the thou shalt not appeal a denial of reconsideration is associated with final rules under Rule 341.
And that's a jurisdictional issue.
Yes, and
which we don't have with collateral orders. But in order to preclude this from happening again, if we fixed our rules and encompassed collateral orders within the rules that otherwise apply to motions for reconsideration, that would take care of this problem entirely. It doesn't help your client, but it would eliminate this problem going forward.
Yes, that would certainly be a way to fix it.
But why not? Why not? I mean, truly, why not? Because what bothers me about what you're talking about is there are a lot of considerations at play, but you have to keep in mind that while someone is waiting, to file yet another motion for reconsideration, or Judge, can I just raise this one more time? The case is going on, and so it screws up the litigation. It delays, it inserts complexities into a case where if 6 months later a judge says, you're right, I should never have done that. Okay, so now you have 6 months of litigation that's gone on. So, and I believe that's the reason for the general rule that doesn't apply to collateral orders but otherwise applies, which is fine. You can file your motion for consideration, but it's not going to stop the litigation.
Right.
Okay.
No, that as I said, that would be a way to fix it. Giving the courts imprimatur what Superior Court did is another way to fix it.
But how does that fix the problem that I just raised, which is you have litigation going on around this time where someone's contemplating whether or not just one more time they're going to ask the court to reconsider something that they've already ruled on. That's not fair to the other parties.
I was referring to the sort of the interlocutory order issue, but I think your Honor is correct that would eliminate that question across the board. What you said would eliminate the question across the board.
Well, I mean, that kind of presupposes there's a problem. I mean, isn't it the case that the way things stand now, the litigant has to pick a horse and ride it? In other words, is this the final order? Is this the order that is going to fit within the collateral order circumstances and take that appeal? Or follow the. So, and I do want to say, by the way, which I should have said at the beginning, is thank you for taking
Absolutely.
this appointment.
Oh.
Thank you very much.
appreciate the opportunity. It actually turned out to be a much more interesting case. When I talked to David Fine about it, it was a rule of appellate procedure issue, and then when I looked more closely at it, and actually as long as you're doing that, I would like to give kudos to your Eastern District Prothonotary office here. When I first got the case, I could not access the record. And the court and the Prothonotary's office couldn't do it. So they actually started sending me giant PDFs of the record. And then all of a sudden, one day they called up and said, oh, we think we got it fixed. And then I was able to access the record. And it was, once I got into the record, essentially it was, if you looked at the last filing in the record, it had every other filing attached to it. So it was kind of a mess, which is why we ended up with a reproduced record, simply because that actually helped me focus on what was going on. But I'm not sure, we might have had trouble getting something filed without the Prothonotary's office helping us out. So thank you very much for that.
I appreciate
and thank you for the opportunity. Just let me close by saying one thing. Essentially, Ms. Khalil followed the case law out there when she did what she did, and had Superior Court simply done the same thing, her appeal would have been timely and it would have been decided, and we might not have been here. So actually it was, in some ways, she's here because Superior Court failed to follow its own rules. Now, whether that survives this case or not remains to be seen, because it's not clear to me the court thinks it has jurisdiction over the appeal to begin with, so we'll see what happens. But I would just close by saying we will rely on our brief for the arguments we made. I won't take up any more of the court's time. I appreciate both the time and the opportunity. And unless somebody else has any further questions, oh, and just one other thing. I think our disagreement was, that Ms. Khalil's so special. The argument isn't that she's special. The argument is that once there's pro bono representation, there's a higher level of practice expected from lawyers, and that is the public policy, which
that would be a new ruling by our court.
Oh, yes,
accepting
absolutely.
that.
Absolutely, and as I said, in our briefs we distinguished both Shear, or we tried to at least anyway, Shear and Bacone, which was another case involving disqualification of counsel. So we'll stick with those arguments. That we made, and we appreciate the court's time and attention.
Thank you, Mr. Whitaker. Your client was well served. Thank you. We are going to take a recess for lunch until 12:30. Next case, Mr. Minnick. Good afternoon.
Good afternoon.
In this case, appellant was charged with first-degree murder and other offenses related to a fatal shooting in Philadelphia. During a portion of jury selection, the trial court excluded public spectators from the courtroom, including appellant's family. During this time, and over appellant's objection, the trial court swore in 60 prospective jurors, gave them general instructions regarding the responsibilities, explained what they could expect during trial, and inquired about each prospective juror's familiarity with the trial judge, the parties, attorneys, potential witnesses, any knowledge of the facts surrounding the case. Thereafter, the trial court permitted the public to return to the courtroom to observe individual voir dire questioning of the prospective jurors. Ultimately, the jury found appellant guilty of all charges. He appealed to the Superior Court, arguing that he was entitled to a new trial because the trial court violated his Sixth Amendment right to a public trial and committed structural error by closing voir dire to the public after he requested that his family be permitted to remain in the courtroom, failing to consider reasonable alternatives to the closure before excluding the public and his family, and failing to place adequate findings on the record to justify its decision. The Superior Court affirmed appellant's judgment of sentence, finding that the number of prospective jurors and limited seating in the courtroom created an overriding interest that justified the courtroom closure. It further determined that the closure was no broader than necessary to address those spacing concerns, and that the trial court placed sufficient findings on the record to justify its decision. We accepted review to address the propriety of the Superior Court's determinations. We also directed the parties to address whether the courtroom closure was de minimis and whether de minimis closures implicate the public trial right and are subject to the standards announced by the U.S. Supreme Court in Waller versus Georgia and Presley versus Georgia. Please proceed.
Good afternoon, Your Honors. John Rooney on behalf of the appellant Antoine Roper. And in this case, the trial court did commit a structural error when it engaged in a total courtroom closure in violation of the appellant's Sixth Amendment right to a public trial. Now, whether this is de minimis or not, Waller and Presley still apply, and the trial court has to go through the analysis of those factors. They have to find that there's an overriding interest that's likely to be prejudiced, that the closure is no broader than necessary to protect the interest, and a trial court has to consider reasonable alternatives and make adequate findings on the record. Just because it's de minimis doesn't mean that Waller no longer applies or that Presley no longer applies. That's the law of the United States Supreme Court, and it's still good law. And in this case, they did not analyze those factors whatsoever. What they did is they invited the veneer in, it's a 60-person veneer, and then they said there is no room for any spectators, specifically excluding the defendant's family. And trial counsel petitioned the court to have defendant's family present during jury selection.
Counsel, let me stop you there, because it's an issue that I kind of came up with. How do you contend that occurred?
Excuse me?
How do you contend that occurred? Because you said he petitioned the court to have it open. From my reading of the record, after the court closed the courtroom, the trial judge, which was Judge O'Keefe, was talking to defense counsel, and defense counsel said something along the lines of, Judge, I think there was a Supreme Court case that came down, something along the lines of, that's not a good idea.
Yeah, and he asked to have the family in. And then there was an off-the-record conversation, which is part of the issue, too.
Do you think that's enough to preserve this particular issue for?
I think it is preserved by the record. And it shows that he said, based on that case law.
Well,
right?
He didn't even cite the case. He said there was some kind of case, and the Judge O'Keefe said, yeah, I think I heard something about that. Do you know the name of the case? And he threw a joke at him. He said, oh, now you're really testing me. I have no idea what it's all about. And he says, for the record, I just have to put my objection on the record.
Yeah, the objection to having the family removed from
You
the
think that's
courtroom.
enough to kind of preserve
I think that is
the
preserved.
Sixth Amendment public right trial objection?
I think so.
Okay.
I believe so. And the Sixth Amendment right to a public trial applies to voir dire. And, part of the argument here on the Commonwealth's behalf and what the court is questioning is, was this de minimis? Well, de minimis is not a standard that has been adopted by Pennsylvania state courts at this point in time.
There's a two-part, I'm sorry, I don't mean to. There's a two-part Commonwealth argument. The first one is that this was during the general instructions, and that general instructions really don't apply to voir dire because all they did was identify areas of inquiry which were actually asked about in individual voir dire. When individual voir dire happened, the family was allowed back into the courtroom. So one of the questions I'm sure you're going to get from that side of the room is, where do we draw that line?
Well, that's the issue when you say something is de minimis. What is the metric? Is it 20 minutes? Is it 40 minutes? Is it 2 hours?
Is there even a violation of the right to a public trial?
There is a violation because it's a structural error. And
Only if we find that this was voir dire. Every person who gets a jury notice comes to the room downstairs in the CJC, right? Or in City Hall. They're given general instructions. They're asked to fill out the forms. Is that part of voir dire?
well, this was in the courtroom.
I understand that, but I'm asking you, was that part of voir dire?
No, that wouldn't be part of voir dire.
So when they bring them up to the courtroom, in this case, they bring 60 people up, they're sat down. The judge says there's no room in the courtroom. I'm just going to ask you to step out for general instructions. He gives them general instructions. We've all seen it. Everybody's given a little number. They're asked certain questions. They put the number up. Then when they get to the individual voir dire, you inquire about why they raised their number up. So that's what I'm asking you. What's voir dire and what's not voir dire? Because this happened during, the courtroom was closed during the general instructions, no different than when they appear downstairs in the jury room. And then the family was allowed back in for the individual voir dire.
May I supplement that question, Justice McCaffrey?
To the extent there was one.
What's that?
Yes.
With respect to the individual questions, I agree there were no individual questions, but there were beyond general instructions. There were general questions such as, do you know the defendant? Do you know his family members? Do you know counsel? And those questions were asked without the defendant's family sitting there, right?
Correct, and the
So
family was denied the opportunity to participate then.
And then those individual questions are used to identify follow-up questions for the individual voir dire, right?
For which the family members were committed.
Correct.
But that would be the start of voir dire when they were excluded.
Well, they weren't downstairs when the prospective jurors showed up to answer the questionnaires, were they?
No, not the questionnaires. They're not down in the main room down
Why
there.
doesn't that count for voir dire then?
But when they invite them into the courtroom and begin to actually select the jury, that would be voir
That's my
dire.
point. Where does that start in your mind? Is it
That's the issue with the de minimis standard. That's the issue. What is the metric?
Well, let me ask you this question then. What's the difference between what is asked in the general and what's asked in the specific voir dire?
We don't know based on the record that's before the court. It wasn't really stenographically transcribed. And there were questions asked, like, who do you know? Do you know anybody involved in the trial? Is there any reason you can't participate? And the family wasn't included in that process. And as a lawyer, sometimes you might want to consult with the family.
I'm sorry, I couldn't hear Justice.
Why wasn't it
Well,
transcribed?
so the portion where they were excluded was transcribed. And then individual voir dire, when that started, we don't know because that wasn't transcribed.
It doesn't matter under your theory, though, correct?
Correct.
Okay. And the jurors were sworn.
My point was that maybe it wasn't transcribed because voir dire, as described by Justice McCaffrey, hadn't commenced. That's my point. Sorry.
Our position would be that voir dire had commenced, that the guarantee of a public trial extends to voir dire, per the case law that's relevant, and that they were excluded from the voir dire. And if we start talking about de minimis, no harm, no foul, we're essentially getting into, is this a harmless error? Is it prejudicial? And this is a structural error in which you're entitled to.
Counsel, following your logic, when they hold a sidebar during voir dire off the record, is that structural error? Because it's not open to the public.
When they hold the sidebar, well,
Off the record.
if they're excluded from the courtroom, if it's a total courtroom closure.
The concept is it's a public trial. The excluding from the courtroom isn't the issue. It's that people are not permitted to see a public trial. That's the intent and the concept. Not we're just moving the family out. It's that they're precluded from participating in a public trial. The question I have for you, if that's the logic of your argument, is the sidebar that they had during voir dire between counsel and the judge in a public courtroom, but not heard, is that violation of the concept of a free and public trial, or a public trial?
No, not if the family and the public's in the courtroom. I would say it's not.
And why not? They're not able to hear, they have nothing, they don't know what's being said.
But they're present there, and they can ensure the fairness and part of the principles behind this, right, of the Sixth Amendment.
They could be assured when the prosecutor says, I don't like him, let's convict him.
Well, the
Defense
attorney for the...
said, he didn't pay me, and the judge says, good, I want to send him to jail. It's all possible. But so that's permitted under your argument.
Well, the attorney for the defendant could then engage with the family and talk about what happened at sidebar and get their input.
Is that any different than the lawyer going outside and speaking to the family, saying, hey, they just asked if anybody knows your son, but we're going to get into the details and we'll understand why?
Well, under that logic, we can just close the courtroom, not have anybody present during voir dire.
Yeah, but that doesn't, I'm not following what you're arguing. You
Yeah,
keep
me
saying
either.
about consulting with the family. The right is not the family, the right's the defendant. The defendant has the right to a public trial.
Yes.
And we have that, we give that right to the defendant to make sure that the public has a right to see what's happening in the courtroom. If, following what Justice Doherty said, if as a defense counsel and the prosecutor go to sidebar with the judge, what right's being violated?
I didn't say that would be a violation if they're in the courtroom and the courtroom's
But my
not
point
closed.
is, why not? What right's
Well,
being
I
protected?
think the important point is, sorry, I didn't mean to cut you off there.
No, I'm just...
The important point is that if you engage in a courtroom closure, which is exactly what happened here, it's on the record where they say there's not enough room, family's got to get out. They said don't even stand in the hallway, go get something to eat, come back in 2 hours. That's a total courtroom closure.
I understand that, but it's a courtroom closure for what? Say we had a courtroom closure for a motion to suppress where you have an undercover agent or you have a confidential informant. The case law says in those circumstances, you're allowed to you're allowed to close the courtroom. My question to you is this, and we've all done these. 60 people come in, they're all given a number. You ask general questions, all right? Do you know anybody here? Number 4, number 15, number 21 goes up. Court officers writing these numbers down. You're not asking follow-up questions, right? You've picked juries before in Philadelphia.
Correct.
Judge isn't going to say, who do you know, in front of everybody else, because obviously you don't want to prejudice anybody. So all you're doing is you're identifying areas of inquiry for the voir dire, the individual voir dire, right? You agree with me on that?
I agree with you.
What's the difference between that and when somebody fills out their questionnaire downstairs?
Well,
And they fill out information about where they're from, what neighborhood they're from, do you know anybody in the system? They're identifying general areas that you're going to get into under individual voir dire. So the courtroom's closed for general questioning, and then the family's let back in, and all of these people who showed up with a number, put their number up, are then asked about their questionnaire, and then they're asked about the follow-up questions on the general. So my question to you is, what's the violation of a right to a public trial if the family's allowed back in for the individual voir dire?
What Your Honor is suggesting is that it was harmless error.
I'm not suggesting anything. I'm telling you how the system works. I'm asking you where the line is drawn.
I
Because
think
in other words, I guess my point to my simple question is this. When does voir dire start in your mind? Does it start when I get the notice and have to go down and fill out the paperwork downstairs?
No, I wouldn't think so.
About when...
I think when they come
about
into
when
the courtroom.
60 people are called and they're led up and said, you're going to Judge Doherty's room in courtroom 602 for a trial today. Does it start then?
When they go into the courtroom to begin the jury selection process.
When does that begin, though?
When they go into the courtroom.
So there's general instructions and then there's specific instructions. So what right is violated if I'm preserving my rights by allowing the family back in for individual voir dire? Isn't that when the selection starts?
But it started before that. And what they did was they totally closed the courtroom. When the jury was invited into the courtroom and they did the initial questioning, and there was some further questioning there, and they kicked the family out and said, come back in 2 hours. That's a total courtroom closure. And the only reason that they gave is that there was no room, and the case law tells us, Presley says, that capacity is not a reason to exclude the public from the room. They could have had a smaller veneer, invited less potential jurors in.
Isn't your argument also that there wasn't enough information put on the record to tell if this was justifiable, that not every closure of a courtroom is objectionable if you can demonstrate that there simply wasn't room, there was no way to divide up the jurors, there wasn't a bigger space, there wasn't an overflow space? Is that part of your argument?
That is part of the argument. And I would say that capacity issues have never been deemed an overriding interest. And if that was going to be the justification for an overriding interest, there needs to be reasonable alternatives explored. And again, my example would be, instead of inviting 60, invite 45 in. Because isn't the right to a public trial and the constitutional rights of the defendant more important than the convenience of the courtroom?
What would have, going with your 60 to 45, how many seats would the court have to leave available for the public to not violate the Sixth Amendment right in your view?
I don't know if there's a specific number, and again, that's part of the issue.
Well, you just gave a specific number. You went 60 to 45.
That was just
15.
an example.
Okay.
In this case, there were, I think, 4 family members, and they kicked them all out.
What if there's 100? What if this is a matter of great public interest? A police officer shooting, something that all the public's interested in, and 100 people show up and they want to sit in that courtroom. How do we pick a jury?
That could potentially be an overriding interest.
So you think that under that circumstance it's okay to...
If they explore alternatives and place the reason on the record, part of the issue we have here, as Chief Justice Todd pointed out, was that there was an off-the-record conversation and we have an absence of findings or exploring any reasonable alternatives, which they're required to do under Waller.
So the remedy you're requesting is for us to send this back to the trial court to give the Waller factors on the record?
I think at this point, we know there was a total courtroom closure. It's our position that this is a structural error that requires reversal. And when you get into this de minimis, you're talking about harmless error. You're talking about prejudice, which is not an appropriate inquiry under the law. And even if it is de minimis, you still have to go through the Waller factors if the de minimis standard applies, which it doesn't exist here in Pennsylvania. And that's what we're here for, I guess, today, is to determine, is that going to exist?
Counsel, can I ask you a technical question? Did you try the case? Were you here when this occurred?
No, I represented him at the preliminary hearing, and then a different attorney tried.
The one thing that confuses me is as I'm reading the record, one of the jurors, by consent of both parties, was dismissed. Is that the only juror that was dismissed? And I ask the question because how were family members then able to fit into the courtroom that wasn't large enough for the family members to participate in the entirety of the voir dire process?
That's not clear from the record that we have before us. They were just told to come back in 2 hours.
But you had all but one of the veneer was still present in the courtroom.
Yes.
These jurors were sworn before the commencement of their questioning, correct?
Correct.
Is that the beginning of the voir dire process, when the jurors are sworn?
I would say when they're brought into when a veneer is brought into the courtroom.
But I don't know how that's any different than Justice McCaffrey's suggestion that people are filling out forms just to get basic information. Once it takes on the solemnity of the proceeding, commencing by swearing the jurors, isn't that a critical question as to when voir dire begins?
And I think that's the issue.
I'm asking you. Yeah. I mean, suppose they weren't sworn. Suppose it was more like answering questions on a form.
But they already did that part.
I'm aware of that. That's why I'm asking you, does it make a difference in terms of determining the commencement of the voir dire proceeding that the jurors are sworn before any of the questioning commences?
If there's trying to be establishing when exactly voir dire begins, that would be a different question.
But that's what the purpose of this questioning is. I mean, there's an argument here that this was merely administrative and it wasn't actually voir dire. And I'm assuming you're taking the position that is, in fact, this was voir dire.
Yeah, I would disagree that it wasn't voir dire.
And why do you say it's voir dire?
On the record, the judge says we're bringing in the panel, we're going to give some instructions, we're going to ask some general information. They excluded one member. That's the jury selection process. It began.
So I guess the move we're trying to make you make, that you're resistant to make, is I want you to forget about your client's case, and I want you to talk more abstractly about the principle of when voir dire begins. Or I could just ask you whether you think it's voir dire or voir dire, which would be a very interesting conversation. But we're trying to get at least the questioning is trying to get at, the Sixth Amendment right attaches at voir dire, which occurs when X happens. Not X meaning this case, X meaning in Pennsylvania. When does voir dire start for purposes of Sixth Amendment right attachment?
I would say when the panel is brought into the courtroom.
Before they're sworn.
Yes.
What if they're not brought into a courtroom and they're brought into a conference room? What if see why we're sort of asking these questions? What if the jury selection happens in an anteroom somewhere, not in the actual courtroom?
Well, if jury selection were to happen in some sort of ancillary room, I would suggest that the public or the family would have the right to be in that ancillary room.
Okay, so again, in the time frame that Justice McCaffrey was asking you, and sort of laying out practically how it happens, at what point, so when the jury was brought into the first room and given the questionnaire, not the courtroom, but the first room and given the questionnaire, you believe that's voir dire?
No, I would say no.
Okay, so it's something about being brought into a courtroom and being asked questions.
Brought into the courtroom where the trial is about to take place.
And in this case, the transcript indicates that the veneer was sworn prior to Judge O'Keefe asking them to raise your hand if you know anybody or don't know anybody. In the event that the voir dire was deemed by the court to begin when the veneer is sworn, your concerns about the inability of family members to assess whether a veneer person is telling the truth about knowing or not knowing anybody in the case could be assessed. That's inarticulate. Let me rephrase it. If the voir dire is deemed to begin when the veneer is sworn, then your concern about structural error remains, doesn't it?
Yes, I would agree.
Okay.
So the swearing, see, that's a very straightforward rule.
That's why I asked the question.
A straightforward rule is, and it just so happens to be helpful with you in this case.
Yeah.
But it's a very straightforward rule that the Sixth Amendment right attaches when the veneer is sworn in. Period. That's when voir dire
Just
begins.
say yes and move on.
We don't want
Yes.
an
Yes.
we don't want an 80%
Okay.
rule. We want a rule.
And if I could just follow, so and at that point, the questioning of the veneer is eliciting responses which you deem material to the public trial right under the Sixth Amendment, including, for example, do any of the veneer persons know the defendant or the witnesses by a show of hands, all of which occurred after they were sworn in this case, right?
Correct.
And that's the structural error, that no Waller factors were applied, so you have a Waller and Presley structural violation.
Correct. And even if we're adopting a de minimis standard, you still have to abide by the Waller factors.
Well, and it doesn't, according to your logic here, it doesn't matter if the voir dire takes place in a courtroom, a conference room, an annex. It's a court proceeding. It's an official proceeding that takes place once the jurors are in that room, and particularly once they're sworn. Doesn't matter.
Yes, I would agree with that.
I find it kind of interesting that you're critical of the trial judge for not announcing the Waller factors doesn't cite the Waller case, and basically says, there's a case out there that if you close the door, then you're in trouble, so you shouldn't do it.
I think the objection was made. The objection was made, a petition was made to have the family remain present. I think that preserves the issue. Like asking for the family to remain in the courtroom. Not actually filing a petition, but asking the court to allow them, yes, correct. In this de minimis standard, in the circuits and in the state courts that have adopted this de minimis standard and tried to find an exception to Waller, it's essentially trying to circumvent the Supreme Court precedent, which is still good law.
What circuits or courts have not accepted the de minimis standard?
I believe there's 13 states that have accepted it, and
What courts or states have not accepted it?
I would have to get you a letter on that.
The Washington Supreme Court has rejected it.
This is for the litigant and the litigant only. I'm just kidding. It's a joke.
But that was a good objection.
It was from my cousin Vinny.
So, just to make one final point, even if Pennsylvania were to adopt a de minimis standard, the courts around the country that have adopted that standard have found that in order for it to be de minimis, the courtroom closure needs to be limited in scope and in duration. This particular courtroom closure was not limited in scope. It was a total closure. The family was told to get out of the courtroom, not even be in the hallway, go to lunch, come back in 2 hours.
No, that was the judge being courteous. I'm not going to necessarily hold that against the judge. I get it, but the Supreme Court of the United States has not spoken on this de minimis standard yet in terms of structural error.
Correct.
So if we were to adopt it, there's probably a fairly good shot that someone might seek SCOTUS review on the Sixth Amendment question.
I would think so. Unless there's any further questions?
Thank you, Mr.
Thank you very much.
Hear from Ms. Blau.
Good afternoon, and may it please the court. Sade Blunt, representing the Commonwealth. Defendant's right to a public trial was not violated here. The closed portion of the proceeding in this case was administrative and did not implicate the concerns that the closed voir dire and Presley implicated.
But was it voir dire?
That's the question. And so it's the Commonwealth's position that voir dire had not begun yet, because voir dire encompasses the individual examination of jurors. And what we know is that that did not happen here. The judge...
Could I just interrupt you a moment?
Sure.
Just from a practical standpoint, I tried a lot of cases, not criminal, civil cases, but voir dire to me was when it began, when the general questions, the general instructions began. It didn't matter if they were general or individuals. The jurors were herded in and they were sworn in, and then voir dire began. How are you limiting the definition of voir dire to individual voir dire?
And if I could piggyback on that, isn't it the actual oath that is taken by the jurors, potential jurors, that initiates the concept of voir dire?
I am actually not aware of whether or not it's the oath that initiates the actual voir dire, but what happens in this case is that the court just briefly greets them, gives introductory remarks, and asks them questions based on the responses that they had already privately checked off. What's important is that no jurors were challenged at this stage, no jurors were excluded based on the determination of those questions. The court just gave those general questions. And so, in other words, what happened here, the closure here covered nothing more than the administrative sorting necessary to begin voir dire. And what,
I apologize. So
Sure.
I'm trying to gather your argument. The issue here is structural error.
Sure.
Voir dire equal, or let's say prohibiting voir dire equals structural error. That's what our law says. You can have structural error if you refuse to permit family for the voir dire portion. The concern we now have is let's drill that down and say what commences voir dire. What's your position?
Our position is that voir dire will commence at the individual examination of jurors. So once the jurors are questioned individually based on their individual responses, which is what happened here, and the family...
Let me follow up, Counsel.
Sure.
You're saying based on their responses. What, from a constitutional perspective, if they are giving responses, and they're giving responses when they're sitting there in this initial period after being sworn, and they're being asked questions by Judge O'Keefe here that are significant. I mean, that's why they're being asked, and being asked by a show of hands, and in fact, some are going to be excused on this basis, and the exclusion of the closure of the courtroom did not follow any Waller factor process, any of the things that Presley and Waller envisioned about balancing, because it may well have been that after such a balancing, the judge would have been well positioned to, in fact, close the courtroom, but that didn't happen. So what we don't know what we don't know. We don't know what persons on that veneer might have been known to some family member who could have then told defense counsel or the defendant, hey, you know, that person who said they didn't know or did know, they do, and here's who they are. I mean, that's just one scenario that is served by a public trial right. So how would you justify, after Waller and Presley, the court's failure to engage in any kind of balancing prior to closing the room?
Sure, Your Honor. So our position is that the court was not even required at this instance to consider the Waller factors because the Sixth Amendment right hadn't been implicated. The court must consider the Waller factors when the public trial guarantee attaches. And our position is that it hadn't attached here, and so the court wasn't required to even consider the Waller factors. And again, there are gaps in the record as to what exactly happened or what types of questions the court asked the jury, but this is defense counsel's claim, and so it would have been his responsibility to make sure we had a full and complete record, and he failed to do so.
Counsel, can I follow up on that? Because from the record, the judge made clear that the courtroom was being closed because there just wasn't enough room. Under Presley, it's the judge's obligation to consider alternatives, whether or not defense counsel suggests alternatives. Isn't that implicated here?
Our position is that it would not be implicated because, again, we believe that this was an administrative sorting proceeding that happened before voir dire began.
Let me ask you this question. When the individual questioning begins, are the jurors re-sworn, or are they still bound by the oath that they took to tell the truth and whatever else they attest to when they were sworn prior to the individual voir dire?
Unfortunately, I'm not familiar with how
I don't
it
see
works
anything in the
trial
record that would suggest that. They're sworn to tell the truth to the questions that they're being asked in this general process. So I'm just trying to decide how the individual voir dire takes on any consequences. They're being asked follow-up questions to answers that they've given under oath in secret. So, I mean, it just seems to me that the entire concept of the right to an open trial is immediately implicated once the oath is taken and they start answering questions.
And that's a fair point, Your Honor. Again, I'm not aware of whether or not they're sworn, and again, it's not clear from this record because it wasn't transcribed. But I would like to note, even if this court was to decide that the Sixth Amendment right did attach at this point, the closure here was too trivial and de minimis to amount to a Sixth Amendment violation.
I don't, by the way, just two things, counsel.
Sure.
Pardon my interruption. Procedurally here, I have the transcript, so I'm not sure what you mean by a gap in the record. I'm looking at the transcript of these proceedings from which family members were excluded and anybody else. But I don't know with respect to the latter point you were making here, I don't know how we can cabin the defendant's Sixth Amendment right by saying retrospectively that this was just administrative and unimportant, because public trial means public trial. It seems to me that the issue is whether things began when that veneer was sworn. Because if it did, if the public trial right attaches when the veneer is sworn, then I think you have a Waller-Presley problem. And you know, there's no bad intentions here on the court's part. I understand what he was doing, but I think I would ask you to react to this. Didn't he just make a mistake by failing to undertake the balancing that he apparently didn't know that SCOTUS precedent required him to do?
What was in the mind of the judge at the time, I'm not sure whether or not it was a mistake. I think the judge had specifically said on the record that we're just going to do some preliminary questions, and then once we're done that, we're going to let the family back in, and voir dire would begin at that point. He used the term jury selection would begin at that point. So it's my understanding, just based on the record, that the judge didn't consider the Waller factors because the judge, too, didn't believe that the Sixth Amendment was implicated at this point.
That was the basis of my original question.
I'm sorry, I couldn't hear you.
That was the basis of my original question about waiver. Waller wasn't brought up. The Sixth Amendment wasn't brought up. Right to a public trial wasn't brought up. This was defense counsel sitting around with the prosecutor to Judge O'Keefe, and one of them happened to say before the panel was brought in the room, there was some recent case out there that said it's a bad idea to close the courtroom. And in response, the judge said, do you have a copy of the case? And I know that because I was laughing, because I know the defense counsel, I know the prosecutors. Defense counsel said, now, Judge, you're really testing me. He said, no, I don't. But for the record, I'll put my objection on the record. That was it. There was no Sixth Amendment right. My client's got a public or a private right. So did the judge make a mistake in accordance with Waller? Absolutely. He closed the courtroom without understanding what the violation was and what the claimed right was, which is why I keep asking about whose right is it? Is it the defendant's right? Is there a prejudice that inures from that?
Well, and can it be waived if it's structural error?
Correct. It cannot be waived if it's structural error. So therefore, like Justice Weck said, you've got a Waller problem because nobody had any idea that this was a Waller Sixth Amendment right. The issue then becomes whether or not we're going to adopt the de minimis standard or not. Because if we follow what the United States Supreme Court says, you've got a clear violation by closing the courtroom, and the judge just didn't understand it. The only question is whether or not the remedy is going to fit the violation under the de minimis doctrine.
Yes, Your Honor, and it's the Commonwealth's position that it would not. Pennsylvania courts have never specifically addressed the issue of whether or not an improper closure can be too trivial or de minimis to amount to a Sixth Amendment violation, but our federal courts have, and they've held that not every improper partial closure implicates the Sixth Amendment.
Let me ask you this. Isn't it possible that the reason SCOTUS has never gone down this Second Circuit de minimis route is that when we try to carve out exceptions to avoid the consequences of structural error, we end up eviscerating important constitutional rights like the right to a public trial? Why don't we just confront the reality that, through nobody's bad intentions, we happen to have structural error here and keep the law clean that way?
Well, Your Honor, the right to a public trial wasn't infringed here because if the court looks to the factors that the Waller court had pointed out are furthered by the public trial guarantee, and that's ensuring a fair trial, reminding prosecutors and judges of their responsibility to the accused, encouraging witnesses to come forward, and discouraging perjury. In the jury selection context is encouraging potential jurors to respond truthfully. Those values weren't infringed upon in this particular case, right? The first two are not even implicated because no witnesses testified, and this occurred before the jury members were even questioned individually.
But they answered.
And they were sworn.
They answered individually, right? You're asked, does anybody here know the defendant's family? And they're expected to raise their hand.
And this is where I mentioned that there's a gap in the record as to what actually occurred at the jury selection process. But the The jurors were broken up into two groups based on the questions that they gave. They raised number cards, and then they're broken up into two groups. The groups that answered the cards remained in the courtroom, and then the second group was excused from the courtroom, and then the family members were brought back in. And the court, it's not transcribed, but then at this point, this is where the court asked them individual questions based on their responses. So the defendant's family is present when the jury are asked individual questions based on the responses they gave on the questionnaire and the responses they gave to the jury's questions.
So that again, that goes to I think the Attorney General's position, and goes back to this debate we had over when does voir dire start. And you're saying voir dire does not start when the general questions are asked, but when the specific questions are asked?
When the specific questions are asked.
And do you have, what can you cite to us a jurisdiction that has said that is the triggering point for when voir dire arises?
I cannot cite to any case that says exactly what point voir dire actually starts. It's just our position in this case is that...
The Attorney General, I apologize, the de minimis standard is a little bit unappealing to me, not completely ruling it out, but a little unappealing to me for the reasons that Justice Wecht pointed out. But the Attorney General's brief, I thought, was interesting in the sense that they didn't argue for de minimis, by the way. The OAG did not ask for a de minimis standard, but they sort of tried to create the difference between substantive voir dire and sort of administrative voir dire. Is that what you're kind of advocating for? Is this idea that there's sort of this administrative part that we really don't worry about, but the substantive part? And if that is what you're arguing, how do you get past the fact that they were sworn?
So yes, that is what I'm arguing, that this was the administrative portion of it. I don't think that the fact that they were sworn changes things, because again, they're not questioned individually until the family comes in. And so when we're looking at the factors that Waller has said was promoted by the Sixth Amendment guarantee, none of those are implicated at this point with what occurs here during the closure.
If I just might follow up on that, something significant happened based upon their answers during the generalized voir dire after being sworn in. They're segregated into groups. And depending on the answers that they gave during that session to which the public was not invited, it had a consequence. They were put into certain groups, asked different kinds of questions, and the public had no way to know why that particular protocol was being followed. And all of which, once again, was driven by answers that the veneermen gave while they were under oath. And that's why I'm struggling with this notion that nothing substantive happens during that general questioning of the veneer.
Yes, they are segregated into separate groups, Your Honor. They're segregated based on their answers, and it's once they're segregated that the jurors are questioned individually about their responses. So that's when the judge gets into whether or not they know any parties, whether or not they have any ethical or religious beliefs that would prevent them from presiding over the case.
Right. Okay, I think we understand the case. Any other questions? Thank you both very much.
Thank you
Well
so
done.
much.
Thank you. The argument is concluded. In case you wondered when things began and concluded, this is done. Good afternoon. In this appeal by allowance, we must determine whether, under sections 1127, 1128, and 1129 of the Public School Code, the Board of Directors of a school district may appoint a hearing officer to preside over a termination hearing for a tenured professional employee without any of the board members attending the hearing, and then vote to terminate the employee based upon the record made by the hearing officer. Please proceed.
Thank you, Your Honor. And may it please the Court, Bruce Merenstein, on behalf of the School District of Philadelphia. With me today are my co-counsel, Sam Silver, and Paul Cianci. The Commonwealth Court's decision is inconsistent with long-standing practice in the Commonwealth, both at the local and state government level, and inconsistent with this Court's precedents. It also ignores the context in which these provisions that the Court is here to interpret today are found, which is the Public School Code.
What's the context, Mr. Merenstein?
The context is the Public School Code, Justice Wecht. In the Public School Code, that context is important in a couple ways. First,
As important as the text?
I think the text has to be interpreted in that context. I don't think it's more important or less important. I think that's part of the textual interpretation, is looking at the context rather than...
Text is not the most important thing for us to look at when we're interpreting the text?
The text is the most important thing, but I don't think the text can be interpreted outside of its context. I don't think you can just take the words outside the context of the provisions in which they're found, and particularly the entire Public School Code in which they're found. And I think that this Court has said as much with regard to this very part of the Public School Code, the part involving hearings and terminations of professional employees. This Court has said we have to keep in mind the overriding purpose of the Public School Code is part of the constitutional requirement of providing a thorough and efficient system.
If I could just follow up briefly. The text that I'm focusing on here is section 1127, which says the Board of Directors shall conduct a hearing, taking out what's in between. The Board of Directors shall conduct a hearing. So what part of Board of Directors does not mean Board of Directors?
Well, I think the real question is the conduct. There's no question it's referring to the Board of Directors, but the Board of Directors shall conduct a hearing does not mean, and there is precedent for this, Your Honor, but does not mean that the Board of Directors shall personally preside over a hearing and attend the hearing. And I think if you look at statutes after statutes in the Commonwealth, there are statutes that provide the State Civil Service Commission shall conduct a public hearing. There are statutes that provide that the Real Estate Commission shall, quote, hold a hearing. The Secretary of Labor and Industry shall conduct an investigation, and on and on. And in none of those cases, none of them, are the secretaries, are the commissions, are the boards personally conducting...
Section 1128, the immediately following section, says that all testimony at the hearing shall be taken under oath, and any member of the board of directors shall have the power to administer oath. And then the next section the General Assembly made, section 1129, says after fully hearing the charges, the Board of School Directors shall by 2/3 vote to be recorded by roll call. So it seems like we have three sections here where the General Assembly instructed the board will do this. And what I don't understand is how you can invoke some context to get your elected school board out of its statutory obligation to do what the General Assembly said it has to do.
Well, to be clear, we're not getting the school board out of the obligations. It is doing what the General Assembly said. And if I can take those one at a time, Section 1128 says it simply confers power on board members to administer oaths. It does not say they must administer the oaths. Other individuals, notary publics, the court reporters, are authorized to administer the oath. And so Section 1128 really doesn't do any work here because it's simply conferring a power on the board. Section 1129 says that the board will vote after hearing the charges, as Your Honor pointed out. This court in Foley Brothers, and it has not receded from the ruling in Foley Brothers, specifically said that the requirement of hearing the evidence does not mean, quote, physical oral reception. It has said rather, it simply means that the board must, quote, consider all of the evidence. So this court has interpreted the very phrase in Section 1129, where it says the board, after hearing the charges, after hearing the evidence, must vote, to mean that it must consider the evidence. And so whether it's in Foley Brothers, which was addressing the very term that's in 1129, hearing, or whether it's in all of the other statutes that use the same phrase, the commission shall conduct a hearing, the board shall conduct a hearing, the Secretary of Labor and Industry, of Community and Economic Development, of Agriculture, all of those statutes refer to those secretaries.
Well, you have to be a little bit careful about drawing too many parallels between the state statutes, state agencies and local agencies, in the sense that there are some statutes that give powers to the secretaries, the actual people, the agency heads. And then where they usually do, the regulations, administrative agency law, general rules of administrative practice and procedure expressly give that agency head delegation authority to conduct a hearing. You need to differentiate between statutes that give powers to agency heads versus statutes that give powers to agencies. And that's where I think you're getting a little bit wrapped up, because this statute requires the Board of School Directors to conduct a hearing. It doesn't require members of the Board of School Directors to conduct the hearing. And under local agency law, the Board of School Directors is an entity, not a bunch of individuals. Correct?
I guess I do respectfully disagree. I think
You might not want to.
He's trying to help you.
You might want to agree with me.
Well, but I think I do agree, Your Honor, with your description of the Board of School Directors, but the statutes that I'm referring to similarly refer to a board, a commission.
Some do, but some refer to agency heads to individuals. Your statute here does not say a hearing shall be held by members of the Board of School Directors, meaning individuals. It says a hearing shall be held by the Board of School Directors, which under the administrative agency law is a body politic, a political subdivision, a local agency, if you will.
I think it's some of those things. I mean, I want to distinguish between the Board of School Directors and the school district, which is a government agency.
Sure, absolutely, and you should, correct.
But I think that the state statutes, the statutes that involve state agencies that I'm referring to, and I understand Your Honor's point in that there are different ones and they may refer to individuals, they may refer to boards. The ones that I'm referring to are just like the public school code provisions we're talking about today, that says, as Justice Wecht has pointed out, that say the board shall conduct a hearing, the board, after hearing the evidence, will vote. They have the same language. And in those, the boards are not the ones doing it. It is a hearing officer. In all of those cases, they are relying on hearing officers.
And in all of those cases, though, and again, I'm going to exclude the ones that vest adjudicatory authority in an agency head, like the insurance department, for example. All of those cases where it's vested in an agency, there usually is a separate express statutory or administrative law or regulatory provision that expressly authorizes the appointment of a hearing officer. Your answer to that's going to be this code has a general delegation authority to hire and appoint officials.
That's one of my responses, Your Honor. But I want to distinguish. Your Honor said that in those cases, the ones involving state agencies, there's either statutory or regulatory authority. And I would distinguish between those two, because I'm leaving aside the ones that have statutory authority. There are not many of them that don't have statutory authority for delegation to a hearing officer, but they may have regulatory authority. But as the Court knows, the regulations certainly cannot modify or cannot contradict the statute. And so the point is that the statutes themselves, in the cases that I'm talking about, which is a subset of all of the ones Your Honor is correct, in those cases, just like here with the public school code, there is no statutory authority for delegation, but the delegation happens every day. They're delegating to hearing officers.
Because there's regulatory authority.
Right, but that regulatory authority has to be consistent with the statute.
Well,
there's regulatory authority here as well.
Well, okay, but regulatory, if there's a regulation until it's challenged, it's valid. You're not going to be challenged. You're not here to challenge those regulations. So,
no, but,
so as inconsistent with the statute. But the fact is there is regulations. Now, do you have a regulation that authorizes the Board of School Directors to delegate the responsibility to conduct and create the record to a hearing officer?
There is a board resolution, which would be the equivalent of a regulation that governs obviously just the Board of Education of the School District of Philadelphia, that was enacted, that provides for procedures for these hearings.
Well, that's
and that includes hearing officers.
I mean, but in fairness, I mean, I don't think anybody would be surprised that the board would pass a reg in service of whatever policy it's pursuing. That's fine, but that begs the question of whether it's violating the statute. So you're invoking, as I understand it, two things: the code provision that they'll have all necessary power to carry out the provisions of the Act, which doesn't get them very far if the provisions of the Act require them to hear the case. And the second one is that you invoke is that the board can appoint a solicitor and assistant solicitors. But that doesn't get you very far because it doesn't say they can appoint hearing officers to conduct the hearings that 1127 says they have to conduct.
Well,
so I don't see how you're getting very far with either of those.
Well, again, I think it says more than you can appoint solicitors. It says it can make other such appointments as it deems fit and can define the duties of those officers. And so, yes, I do believe that that provides the authority to appoint, to delegate the responsibilities and duties such as conducting the hearing, such as hearing the evidence. Again, if you look at other provisions in the public school code that have similar language, in the same code itself, it requires the board of directors, not a delegate, of the board of directors to purchase all furniture, to furnish classrooms, to transport students. But nobody would suggest that they have to go out and purchase by themselves, go to IKEA on the weekend and buy the furniture, then themselves put it in. Because it doesn't say they have to do that personally, and they have the authority to appoint folks, administrators, staff, to do that. This is no different. It says that they must conduct a hearing, just as all the other statutes say that.
It says it must conduct a hearing.
Right, but it also says it must furnish the classrooms, and it must transport the students. It says the same thing. It doesn't say the board or its delegates. It doesn't say the school district. It doesn't say the administration. It says the board of school directors.
So what were the lawmakers telling us when they said in 1129, after fully hearing the charges, et cetera, the board shall, by a blank, recorded by roll call. So are you saying that the legislators were telling Pennsylvanians the board can go out and delegate of its own volition to some hearing officer to do a Zoom, and then this hearing officer can report the results of the Zoom, and then the board can, at its meeting, just have a roll call vote to rubber stamp whatever the hearing officer tells them. Is that what you're saying the law provides?
No, because what the law provides, what this court said in Foley Brothers, is that what is required when it says that they have to hear the evidence is they must consider the record. And that's what happens here. A record it's not as if the hearing happens and then they ignore that and then they go off and vote. A transcript is created, all of the exhibits are collected, there's a report from the hearing officer, all of that information is provided to the board. In this case, more than 2 months later, so there's plenty of time for the board to consider that, the board then considered it and voted. In this court, again, in Foley Brothers said that is sufficient. That is hearing the evidence.
Does this board follow the general rules of administrative practice and procedure?
Does the board follow? I honestly don't know the answer to that.
You know what GRAP is?
Yes.
Okay, but you don't know if the
I assume they do. I mean, I'm not solicitor of the board. I don't.
So if they follow GRAP, shouldn't there have been an objection period to the hearing officer's report and recommendation so that the board of school directors can consider the report and recommendation and the objections to it?
I think so, but I do know factually in this case there was more than a 2-month period when the board considered it. There was nothing preventing.
When you say considered it, was there a period to file objections? Was the report and recommendation provided to counsel for the professional employee and the counsel given an opportunity to file objections to a report and recommendation with the board?
I know the answer. The first part of that is absolutely. I think it was June of 2022. All of the information was provided both to the board and to the counsel for Mr. Follman.
Meaning the report and recommendation?
The report and recommendation, the transcript, the exhibits. The transcript was provided, and then 2 opportunities for post-hearing briefing was provided. All that briefing, post-hearing briefing, was provided to the board. So all the briefing.
No, I'm asking about post-report and recommendation.
Right, and I don't know. That information was all provided. I don't know the answer to the second part.
But the report and recommendation was provided.
Absolutely.
Prior to the board's consideration of it.
Well before the board's consideration, and an opportunity to brief the issues. And there was certainly nothing.
You're going backwards. I'm trying to go forward.
Right.
You say an opportunity to brief the issues before the report and recommendation, or after the report and recommendation?
Before and after that. Again, I can't answer whether or not there was some formal, for example, notice of an opportunity to object. There's nothing that was preventing.
You understand usually in the general rules of administrative practice and procedure where there is a delegation to a hearing officer, there is that the spot where the report is provided and there's an opportunity to file objections.
Yes, but I don't believe that that formal process would be followed here. I think here, this is because it's not going to be an adjudication under the Administrative Agency Act. It's covered by the different rules, but I think...
Why is it not an adjudication of the Administrative Agency?
Well, because I think there's a different procedure. So it's, for example, it can't be appealed to the Court of Common Pleas. An appeal after the board's decision goes to the Secretary of Education and then to the Commonwealth Court.
Okay.
So it's a specific
Well, it may not be a final adjudication, but it's
Right,
it's not a final adjudication.
Right.
Counsel,
But I don't think there was
Counsel,
anything preventing...
Counsel, can I follow up on that point?
Sure.
When was the first time that an objection to this procedure was raised by Mr. Follman? Because if I'm taking a look in this particular case, the principal made a recommendation, the board appoints a hearing officer, there was no objection made, there was some back and forth on this particular issue, a hearing was conducted, then everything that Justice Brobson's talking about occurred. When I looked at the record, the first mention of an objection to the appointment of the hearing officer was made in the appeal to the Secretary. So did Mr. Follman ever object before that particular point? And if not, why isn't it waived?
He did not object before that point, and I would actually say that the record reflects he didn't object at that point either. I think the record, if you
He was
really
a willing
look-
participant in this particular hearing with a hearing officer.
He did. He had other objections, for example, to a Zoom hearing as opposed to in
that.
person. He did not make any objection to the fact that it was before a hearing officer instead of the board. He didn't make that objection at the board level. He didn't make that objection at the Secretary level. The citation in the Commonwealth Court's opinion where it said this was raised, and they did not cite to anything in the board level proceedings, which are all in the record. They cited to 3 pages of the transcript of the hearing before the Secretary, which incidentally was before a hearing officer. It wasn't before the Secretary of Education. But those pages say nothing about this issue. You're absolutely right, Your Honor. And in fact, it wasn't raised anywhere until my understanding as at the oral argument in the Commonwealth Court. And at that point, the judges on the panel in the Commonwealth Court raised this issue, and then later, of course, relied on that entirely, and that's the only issue they addressed. But that's the first time that it was raised, which is one reason why the cases that we believe control the outcome here, cases like Foley Brothers and Velasco and Bowling, cases that have said the use of hearing officers in this context with language like this is appropriate and proper and preserves the due process rights. None of that was briefed in the Commonwealth Court
Based
or
upon
before the
that,
Secretary.
based upon that set of facts that you just mentioned, does the Chenery Doctrine have any application to this case?
Is the what, I'm sorry?
Chenery Doctrine? Are you familiar with the Chenery Doctrine?
I don't think so, Your Honor.
I'll save it for later. Look it up.
Okay.
Counsel, just so I'm clear, you're saying that this issue wasn't even briefed in the Commonwealth Court? It was raised by the Commonwealth Court sua sponte during oral argument?
It was, and the court, I don't recall if they invited or were asked if there could be post-argument letters, and short letters were submitted by the parties, and that's the extent of this issue being briefed before the Alicotter petition was filed with this court.
So you're basically saying we should vacate the Commonwealth Court's decision because of waiver?
Well, that's not the issue that the court granted Alicotter on, but it certainly would not be improper to do so. The issue was not raised. I mean, it wasn't raised before the board. You cannot find it in the transcript of the board proceedings and all the emails back and forth between the school board.
I think the only objection he raised was to the virtual nature of the hearing.
Correct. There's no question that was raised, and to the extent that that's been preserved through the Secretary and the Commonwealth Court, which again, I assume it has been, on remand, that's an issue that the Commonwealth Court would have to address, along with presumably the merits of his claim regarding the termination. But this issue, that the hearing was before a hearing officer without the board present, was not raised. That was not raised before the board.
Why didn't you raise waiver?
Why didn't we raise waiver?
It was that argument.
We did in our en banc petition in the Commonwealth Court, because that was the first opportunity.
How about in the petition for allowance of appeal?
Again, candidly, I'm not sure we thought that this court would grant Alicotter just to address a waiver
What if
issue.
you've waived the waiver argument?
Yeah, exactly.
And if that's the case, we will be fine with the court addressing the merits. I mean, I'm not hiding the fact this issue was not raised below. I mean, we weren't going to take up this court's time with an Alicotter petition just to say the Commonwealth Court shouldn't have addressed this issue because it was waived.
Well, that's actually, but see, that's a perfect thing to raise on Alicotter, though, because the Commonwealth Court made a ruling of law that is going to apply broadly across the Commonwealth of Pennsylvania on a matter that, at least I'm going to have to go back and look at it, but on an issue that wasn't even before them. That's the kind of alicata-worthy thing that we would want. We wouldn't have taken his appeal on an issue if he waived it, but you're stuck. If you didn't do an alicata, the Commonwealth Court's opinion was going to stand.
I understand that, Your Honor, but I guess, without getting into sort of strategic decisions that were made in filing a petition for alicata, I think our concern was less so with Mr. Follman's specific case and more so with the holding of the Commonwealth Court. And so I think knowing how few, not meant as criticism, how few cases this court takes, understandably, I think our focus was on the merits decision and the sort of ramifications of that. And frankly, as we said in our alicata petition, we believe, as I was discussing earlier with Justice Probson, I think the ramifications not just for school boards, which we think is certainly significant, but for other boards and commissions. I think that there's going to be additional challenges if the Commonwealth Court's decision is either affirmed or was allowed to stand. And I think that's why that was our focus in the alicata petition, knowing how difficult it is to get the court to grant one.
I mean, this statutory language seems pretty clear. Instead of turning somersaults to avoid having the board simply conduct these hearings, of which there are extremely few, apparently, from the briefing, because most of them go to arbitration, and because you've given us no statistics to indicate some great burden on your elected school board, people who are elected to do this, why don't you simply get your legislative delegation to make a small amendment to the code to get you out of this requirement?
Well, as difficult as it is, as I said, to get, alicata granted by this court, I think it's almost more difficult to get the legislature to make, an amendment, just to satisfy, even an important constituent like the School District of Philadelphia. And so certainly if that's necessary, that's something that the school district may put its efforts towards. But I think, we believe that that the Commonwealth Court got the law wrong, and that when statutes like this one and many, many, many others in the Commonwealth say that a board or a commission must conduct a hearing, we believe that the precedent and the longstanding practice is that can be delegated to a hearing officer as long as the board or the commission, here the Board of Education, as it did, is considering the evidence, is considering the record that's created by the hearing officer.
Sometimes longstanding practice happens to be discovered much later, maybe because of an idiosyncratic teacher who's all wound up about COVID or whatever, to bring it to our attention, and the case comes up and we realize the statute's been violated a lot. That doesn't make it any less of a violation, does it?
It doesn't make it any less of a violation, but again, I don't see how the court can interpret sections 1127 and 1129 to require the board of directors to personally handle these termination hearings, to oversee them, given, that all of the other responsibilities they have. I don't see how it can interpret it to require that and not interpret the probably dozens of other statutes with the exact same language involving other boards and commissions the same way. The other one point factually I do want to point out is that at least in the School District of Philadelphia, and I think in some of the other larger districts in the Commonwealth, it is absolutely not true that these hearings happen infrequently. The School District of Philadelphia has thousands of professional employees. The statement, which is not in the record, I mean, the claim in the Aplts brief that they don't happen frequently is based on looking at the number of appeals to the Secretary of Education, which says nothing about how many termination hearings there are.
We know you have many, many more employees by far than any other district, which makes it all the more curious that you've given us no statistics to support your claim of an onerous burden.
But again, I'll go back to the point. This was never raised. If this had been raised at some point, and certainly, if it had been raised and preserved before the Commonwealth Court, we would have put that information in the record. We certainly can't give that information. I mean, I don't believe. We do give some information, public information, from the Department of Education, data about how many students, how many teachers there are in the School District of Philadelphia. But I don't think that we could just create a record before this court and say, in fact, there are some years where there's 15 or 20 of these hearings. There's some years where there is 10 of these hearings, and that's not uncommon.
But you see, counsel, that's the problem with not raising waiver. I mean, there are a bunch of us sitting up here who spent hours getting ready for this argument. And what you're telling us is you waived the waiver. You made a strategic decision not to raise waiver because you wanted us to look at the substantive issue. You can't really have it both ways.
Well, we made a strategic decision that it was more likely that the court would grant aliquotter on the substantive issue than on waiver.
Okay.
It's not that we, affirmatively said.
You could have raised two issues.
You could have, absolutely.
I understand that. In retrospect, we certainly should have. But again, I think that we made a decision that it was more likely, as it turned out to be correct, at least, that the court would grant aliquotter on the substantive issue. And so we made a decision not to raise the waiver issue. It doesn't mean we affirmatively chose not to raise that issue.
It means exactly that. It means exactly that. You filed a petition with our court raising one issue. We proceeded along the lines that was the issue, and that it was an issue that was preserved. Otherwise, one would think that you would have said this is an unpreserved issue. The Commonwealth Court could not have proceeded along those lines.
I do believe, and I'd have to look back at our petition for allowance of appeal, but I do believe we pointed out in there that this issue was not preserved. We certainly pointed it out in our merits brief that's before the court now. In the section of the brief that's required to show where issues were preserved, we specifically said that contrary to the Commonwealth Court's opinion, this issue was not preserved below. So before we came here today, before Aplt even filed their brief, before we filed a reply brief, we certainly told the court, and again, I believe it was raised in the petition for allowance of appeal. I'm 100% certain it was raised in the merits brief. Not as a substantive argument, I understand that, because we didn't seek aliquotter on it, but we certainly pointed that out to the court. We did not hide the ball in that issue.
Could you tell me where that was in your merits brief?
It's in the section specifically that's required under the appellate rules for preservation of an issue. I don't have it at my fingertips, but if you look in the table of contents, Your Honor, that's exactly where it is, because it wasn't preserved, and we certainly weren't going to tell the court otherwise, and so we pointed that out. But I think the point I was making is because it was waived, leaving aside whether or not we've waived that waiver, because it was never raised below, we had no reason to create a record. We didn't put into the record that the board had a resolution that said that it can rely on hearing officers. We didn't put into the record how many of these terminations happen every year, because it wasn't until the record was essentially closed at the board level, at the secretary level, that this issue came up at the Commonwealth Court.
Speaking of resolutions, isn't it the case that far from doing the procedure which 1127, 1128, and 1129 spell out, the board simply did an assembly line ratification of this as part of a resolution that encompassed a whole bunch of employees. In other words, there was no individual. Not only did the board not conduct the hearing, my understanding is the board never even discussed Mr. Follman or his case, but simply had an agenda that they were handed by some functionary and just voted up or down en masse. I mean, basically the case seems to indicate that, I don't know for how long it's been going on, your school district just doesn't follow the statute, and you're being called on the carpet on it. Isn't that the case?
No, it's not, Your Honor. And I think that what you're seeing is simply at the public meeting where the official vote was taken, there was a vote taken on, I believe, 3 of these terminations. But 2.5 months before that, the board was provided with the entire record of the hearing. They were provided with the transcript, all of the exhibits. They were provided with 2 sets of briefs from the parties. They were provided with the report of the hearing officer. And they had 2.5 months to consider that. They have executive sessions where they talk about personnel matters as they're allowed to under the law. And so it's not as if the hearing officer issued his report and the next morning there's a pro forma vote. It was a 2.5-month period where they are given that information, they're provided with it, they consider that.
Well, hey, counsel, you don't know any of that. I mean, that's not in the record.
Well, it's not in the record.
Right. So we don't. I guess my point is, if there were any. There was an actual hearing, an adjudicatory hearing in front of the secretary, correct?
Before the Secretary of Education?
Yes.
On appeal?
Yes.
It wasn't before the secretary, it was before a hearing officer.
Well, there was an administrative agency law hearing in front of the secretary, an opportunity for the professional employee in this case to plead his case to the secretary, to raise all of these issues about they just stamped, they just did this, they just did that. And were any witnesses brought forward? Was anybody subpoenaed? Were there any requests for documents, anything like that, where these things were developed in front of the Secretary?
Not by Mr. Follman. I mean, this, again, because the issue wasn't raised. This issue was not raised before the Secretary. The issue of, that he relied on a hearing officer instead of having the board be present at the hearing.
Well, that wasn't raised at the Secretary. That was raised at the Commonwealth Court, right?
It wasn't raised in the Commonwealth Court either. The Commonwealth Court
at
panel
argument.
raised it.
At argument. Yeah.
At argument, sua sponte, they raised it. So there was no reason, certainly for the board, for the school district, to create a record on that issue. I also think the law is, including in the Foley brothers case, this court said, where a litigant made that argument, hey, there's no proof that the board members that weren't there at the hearing actually considered the evidence. And this court said that they don't have to have proof. There's a presumption of regularity. And again, here, the facts support that, where you have a 2.5-month period for them to consider it. There's, that they were sent all of this information. There's no indication that they didn't.
There's evidence in the record that they were sent all this information?
I don't know if there is.
Is there evidence in the record of when it was sent?
No, there's evidence in the record of the date of the hearing officer providing his report and the entire record, the transcript, the exhibits, to the board.
What does that mean?
What's that?
What does that mean, to the board?
I think he technically sends it to the chief of staff of the board, who then, and again, I know the next question.
We don't know,
it's not in
right?
the record. I know that it is then sent and provided to the board. That's not in the record because there was no reason to put that in the record because that was not an issue below. But if that was an issue, then there would have been a paper trail. If that was really important to show that the chief of staff then immediately provided that information to the board. I can't believe that the law would be that at that point then, for example, the board has to prove that it spent X number of hours looking at the record or that it looked at this part of the record or that part.
Is there any evidence in the record that his name was ever mentioned in front of the board?
Yes, well, certainly the board.
Did the board ever discuss this guy? I mean, was it ever even, something that they deliberated?
Yes. First of all, his name is in the minutes of the board meeting where the vote was taken on the termination. Second, the discussions of his situation or any tenured professional employee who's facing termination is going to be discussed in executive session. Those discussions of the issues involving discipline and employee discipline and termination are not discussed at a public meeting. And that's, again, consistent with the law. But yes, it's discussed. But again, I certainly hope that the law is not. I can't imagine that the law is that the board has to somehow create a record of its discussions in executive committee or how much time it spent on Mr. Follman's case and whether or not it read all of the testimony and whether it reviewed every exhibit. And again, I think that's inconsistent with this court's precedent in a case like Foley Brothers. That was a similar case where somebody was challenging the fact that certain members of the board were not at the hearing where the evidence was presented. And this court said what's required when the law says that they must, after hearing the evidence, they must vote, is that they must consider the evidence. They must consider the record. And it rejected the notion that the board in that case must prove that it actually did consider that.
But there were board members who heard the evidence in that case.
Right, but the challenge was to the ones who had it.
Well, but that's a question of if there were a sufficient number of board members present to fulfill their responsibility.
Well, but the statute...
Here we have a hearing officer. Let me just ask you one question just for clarity. Are you relying on something other than Section 4-406 for the board's ability to appoint a hearing officer?
Well, I mean, as Justice Weck pointed out, we're also relying on the broader, more general authority in Section 507. But I'm not sure
because
that
406 doesn't really help your cause. This isn't a delegation of authority. This is the appointment of people to assist them otherwise. I'm not sure what you're saying. You're saying 406 is... 406 doesn't really help your cause.
Well, a couple of things. First of all, as I was about to say, I don't think that 406 or 507 are necessary because, again, I believe a reading of the statutes, I think, would allow what's happening here. But the other thing is I think that's exactly what they're doing. They're not delegating it. They still have the authority. They still are required to consider the record. They are still the ones who have to vote. So it's not a delegation of authority. It's an appointment of an individual who's going to assist them. It's going to be their agent and is going to assist them by gathering the evidence. Somebody with that expertise that board members who are retired educators and current educators and civic leaders. Those folks are not able to preside over a hearing
Then
and to
maybe
get.
they shouldn't run for school board. I mean, they ran for school board, the statute says they shall hear it, and so maybe they should do with the job they were elected and assigned to do, or not run.
Well, again, I think we're just disagreeing as to what those statutes say. I think when they say that the board shall conduct a hearing, I think, again, consistent with statute after statute in the Commonwealth, that doesn't mean that they can't retain, they can't, assign to a hearing officer to assist them by gathering that evidence, and then they consider the
Let me
evidence.
just ask you one more thing on this line and then leave you alone on that. Isn't it possible, since you like to talk about the context, which I think is something masquerading for purpose, but you said you want to talk about context, isn't it possible that the context is the General Assembly wanted these people around the Commonwealth who were elected, who stand before the public and get elected, to be accountable for these decisions that are so important to people's livelihoods, a teacher being fired in this case, okay? Rather than some unknown person on a Zoom call whose name nobody will ever remember, making this decision, and then this being on a laundry list of things that in 2 minutes at some board meeting a couple months hence is ratified on a yes/no vote. Isn't it possible that the General Assembly wanted that elected person accountability?
I think it is, and I think that the process that is happening in the School District of Philadelphia preserves that accountability, because, again, I will take issue with some of the underlying presumptions in Your Honor's question. I think that there is no reason to believe that they only gave 2 minutes of consideration. I think that these board members were well aware of Mr. Follman's situation. They voted, they deliberated, and they voted at the outset of this entire process, which they're required to under law, to send a notice of charges to start the process for termination. And then they had, again, 2.5 months. They had discussions in executive session. They seriously considered it. They take their jobs very seriously, and they are accountable. As in this case alone, they're appointed, not elected.
They had discussions about this in executive session?
Excuse me?
They had discussions about this particular
Yes,
matter?
they have discussions about any
But
disciplinary
you're representing
matters.
us today that they specifically discussed this in executive session?
Yes. It's not in the record, so I'm wary to say anything that, that's not in the record, but yes, I can represent that they discuss this, and that I know that they discuss any disciplinary matter. Because, in response to Justice White's question, they do take it very seriously, and they know that that's their responsibility. And so they are employing a hearing officer not to avoid that accountability, to avoid that responsibility, not in any way. They're doing it because they are 9 unpaid volunteers. Yes, they are appointed in this case, and in most cases in Pennsylvania they're elected, but they are 9 unpaid, unexpert volunteers, and so they're relying on the assistants, just like they rely on teachers to teach, the superintendent and other administrators to administer. They're relying on a hearing officer with expertise, a lawyer, somebody with expertise in evidence and procedure to gather the information, to create a transcript, to gather the exhibits, to hear the testimony, not to hide any of that, to provide all of that to the board along with a report that outlines the hearing officer's understanding of the evidence that was presented, and then they are accountable to take a vote. They discuss it in
Are there any other questions for Mr. Merenstein? I think we understand your argument. Thank you very
Thank you,
much.
Your Honor.
Let's hear from Mr. Migliore.
Ready?
Yes, good afternoon.
Good afternoon. May it please the court, I am Rich McGlory, a former 34-year teacher, assistant principal, and summer programs principal for the 4th School District of Philadelphia for 14 years. I proudly stand before you today on behalf of the due process rights of every tenured teacher and principal in our Commonwealth. Our due process rights are under attack today. I don't agree with a word that man said to this court. It is filled with misinformation. This all started at Constitution High School. Let me inform the court, there are 2 students at Constitution High School who were deprived of their teacher illegally.
I'm going to stop you for just a moment, Mr. Migliore. This is not a jury argument, okay?
I know.
No, stop. This is not a jury argument. This is a discussion, an oral argument before the Supreme Court, and we will hear your legal arguments, but we're not going to hear ad hominem attacks, and we're not going to have any showboating. So
right,
let's just make the argument, okay?
Okay, thank you. I apologize, Your Honor, and I didn't mean to be showboating, and I certainly respect the other county. But I just want to point out at the outset, this court said in Smith and PA 1957, time and time again, our courts have stated that the purpose of the tenure provisions of the school code is the maintenance of an adequate and competent teaching staff free from political or arbitrary interference, whereby capable and competent teachers might feel secure and more efficiently perform their duty of instruction. That is...
Counsel, if I may ask, the purpose of these statutes are to provide, say, procedural protections before they terminate a tenured teacher.
Yes.
When you look at the process, was this teacher not provided due process pursuant to the statute?
They were not provided any of the processes required by this statute.
So let's go through that. Did they receive notice that they were going to be terminated and they have a hearing?
They did not receive notice preferred by the school board. The school board did not look at the charges. They did not make the charges.
Then how did your client know that he was being fired and where to appear?
Okay, this is what happens, okay? The Office of Talent put a resolution before the school board without any notice or discussion with the school board, without an executive session pursuant to Reading, the Reading case, Reading Eagle case. They didn't announce executive session to talk about it. They never talked about it. The statement of charges was not attested that the school board met and discussed these charges and that they were this board's department. The Office of Counsel put a resolution that the school board rubber stamped in a vote of several resolutions at once without knowing anything about the case. The charges were drafted 2 weeks later on September 1st, I believe, and they were sent to Mr. Follman by the Office of Talent, not the school board.
But he received notice and he in fact appeared virtually and testified, correct?
Oh yeah, he received that notice that was not preferred by the charges. And I just want to, Justice Doherty, the school board, the Commonwealth Court relied on Jones v. School District of Philadelphia, which is the en banc case and the most thorough case ever, well-reasoned, thorough, of the constitutional rights of the procedural safeguards.
But sir, with all due respect, in your record, is there ever a request for this hearing to be commenced in front of the full school board?
Yes, there was. The court put it right there in the thing. We accepted, he accepted, I accepted for him, he hired me. We accepted a school board hearing to be held before. That is what we accepted. We never agreed to a hearing being held by a hearing officer.
When you were virtual with the hearing officer,
yes. Did
you object to the use of that?
Yes, we did. Starting on page 65 of 65A of our record, the transcript, the first words out of my mouth was, "The Constitution does not stop at the schoolhouse gate. We explained that it was being held in violation of his due process rights, and we put evidence on the record, and we put in the brief, in the recommended findings of facts, the school board, this was not conducted in strict compliance with the school, with the procedural safeguards of the school code, and whether that failure to strictly comply with the procedural safeguards of the school codes is a violation, is a denial of due process, like the en banc court ruled in the Jones case. The district appealed, this court denied their appeal. In the record is the school district's application for re-argument and redecision of the case and reconsideration of the case, in which they raised that issue, and I briefed to Commonwealth Court everywhere in the record, at the hearing, before the hearing, in that response to their application.
Counsel,
Yes.
with regard to your opponent's argument, do you see a difference between a 4406 appointment as opposed to a delegation of duties?
Yes, there's a big difference.
Why don't you share
All right,
with
the
us?
difference is that a solicitor is the counsel for the school district for everything. All right? When they delegate a hearing officer, that was not to the Office of General Counsel. It was delegating that to a person, to a third-party attorney that is not the school board, was not elected. There is nowhere in the school code that there is where the legislator has conferred on the school board the authority to delegate their duty to hold a hearing to comply with Section 1127 and 1129 in their full. It has long been the law since Swing's case back in 1938 that that statute must be strictly complied with, or it is a fatal defect and requires reinstatement. In Jones, Commonwealth Court fully explained that. Right? It's an open meeting before the school board where the teacher has an opportunity to explain his reasons directly to the board why he did what he did. He was not only standing up for his rights, he was standing up for his students' rights to be in school and not be prevented from going to school by an illegal covert surveillance plan, which was never even enacted by the school board.
Counsel, can I just interrupt you really quick? I want to go over here.
Yes.
The way you two seem to be saying different things, so I went to the transcript really quickly to see the pages that you were referencing. I'm trying to follow your argument that you were making about a hearing in front of the school board. And as I read it, you were complaining to the hearing officer that your client did not have a hearing in front of the school board before the school board referred charges to the hearing officer. That was your argument. The issue that the Commonwealth Court is raising is that being in front of the hearing officer was improper, and that's where that you should have been not in front of a hearing officer, but in front of a board.
Yes.
So I'm trying to understand where when the hearing officer starts having the hearing, you say, just hold on for a second. You argue, with all due respect, Mr. Hearing officer, we shouldn't even be in front of you because you don't have the authority to have this hearing. We should be in front of the school board. That's not the argument that you made, at least as I'm reading in the transcript.
It was that it was being held in violation of his due process rights
Right, but
without strict compliance to it.
But the argument you raised specifically with regard to a hearing in front of the board is you were complaining that you had not already had a hearing in front of the board, that before it even got to in other words, you wanted a hearing when they decided to proceed with charges.
No, that's not what I was arguing.
Well, that's how I'm, okay. Well, I
process.
think we're all going to look back. Look, I mean, due process is a flexible concept, particularly in the administrative agency law. So our case law is legion that you do not have to have the ultimate adjudicator decide on a hot record, a transcript. So you can have a compliance with due process and the adjudicator reviewing a cold record.
This is, Your Honor, I ask you to thoroughly read the Jones case, which explains.
I'm familiar with the Jones
Now,
case. I'm just trying to look at. Counsel, hold on for a second.
Hey, just a minute. Mr. McGlory, do not interrupt the justice.
I'm sorry,
Let him
I apologize.
My only question for even starting this line of questioning was I want to give you another opportunity, and this may not be fair but you seem so intent on knowing 65A was the page of the record. I looked at 65A, I looked at 64, 63, and 62. And where you talked about not being in front of the board, your complaint to the hearing officer was, we were supposed to be in front of the board earlier, and my client was never there. They don't know who my client is, but they've put this in front of you, and we should have been in front of the board previously.
I should have been in front of the board previously for the suspension without pay.
Right.
Yes.
Right. But we're not
Yes.
talking about that anymore. We're talking about the merits decision to terminate him.
Right, but I was also talking about their violation of due process by not complying with any of the procedures. And I just want to point out, and I do it in every case, because if I made a special question presented for every one of their violations of the school code, we would have had 15 whether's or not. But the thing is, the question presented at the school district level before the hearing officer was whether the school district strictly complied with the mandatory procedural safeguards
Can I ask you about what happened
of
at
the
the
school
secretary?
code. And I presented to that question at that level whether this district's failure to strictly comply with the procedural safeguards is a fatal defect and a denial of due process.
Can I ask you about the hearing at the secretary?
Yes.
Did you raise with the secretary that the local agency adjudication should be set aside because it was before a hearing officer and not the full board?
Yes, I did. And the court, in its decision, the Commonwealth
No,
court,
I'm asking about the secretary.
Yes.
Okay.
Yes, I made that argument. He did not respond to that argument. I made those arguments over and over again that it was not a hearing before the school board, and the Commonwealth Court referred to that, I think it was in a footnote, explained that I argued that before him, and that it was not responded.
And if I looked at your petition for review that you filed in the Commonwealth Court, I would see a specific item you should reverse because the hearing officer lacked the authority to conduct the hearing.
Yes.
Okay.
I put that in there, and I did it, and PA Rule of Appellate Procedure 216A, I think it is, that a due process, that a issue that is stated takes every subsidiary issue, contains every subsidiary issue, and I take that into consideration when I structure my wording of my questions presented. You will see in the record is that those same two questions presented before the hearing officer of the school district, before the Secretary of Education, and before the Commonwealth Court. The Commonwealth Court looked into the question. The school district's, application for re-argument and reconsideration, they presented that issue, that we didn't raise the issue, and I put in our answer, all the places that we raised that issue, and the Commonwealth Court denied that application. That issue of due process violations and violation of the school code was raised at every step of the way. And as long as we're talking about the record, let's be clear. There is no resolution in that record appointing a hearing officer. There never was, there never is. And the Pittenger, which is well addressed in my brief, and I stand on everything I said in our brief, ruled that the burden of proof that they complied with every provision relies on the school board. Read my brief. I put the whole Pittenger decision which relies on Enrich, which is well discussed in the en banc decision in Jones, which is the controlling and binding precedent in this case, and so are the other Supreme Court cases, including Twer, which is about a defendant, that you have said time and time again that every provision of those procedural safeguards must be complied with, or it is a fatal defect. The school board prefers the charges. Look at the Belasco case. This cited not only by us, but by the district, where this court said that the school board prefers the charges, prosecutes the case, and makes the decision. That's a due process right of Mr. Follman. That was denied. There's no evidence that they even received a copy of the decision. There is no evidence in the record. They never saw that decision. They didn't even know a hearing was taking place.
What are you basing that on?
All right,
How do you know that? What are you basing that on, your statement?
I'm basing because they always just rubber stamp it, and there is no evidence that they read it. And it's my belief, I've done several of those cases. I raised the same issues time and time again. There was no announcement of an executive session compliant with Reading Eagle, which said that they met and in executive session, there was no opportunity ever for Mr. Follman to speak before the board, to object to the decision, which was issued unilaterally to the board, or unilaterally without the board. There is not one communication.
Well, counsel, you're throwing a lot in there. Can I just unpack it for a minute? Yeah. You did get the report and recommendation from the hearing officer, correct?
Yes, it was sent to me, to the council for the school district.
Right. Did you file objections to the report and recommendation?
No, there's no procedure for me to file it.
Okay, fair enough. When you were in front of the secretary, did you call any board members to question them at the hearing on whether they reviewed the matters, whether there was an executive?
The secretary does not allow testimony. They just do it on oral argument. They just do it on, we write pre-hearing briefs for the secretary, and then the secretary rules on our briefs and the record down below.
Is that written in the code somewhere, that the secretary does not conduct an adjudicatory
That's
hearing?
what they do. That's what their practice does. They don't call.
Well,
additional
I did some of these when I was a Commonwealth Court judge, and I reviewed plenty of records on professional employees that were created in front of the Secretary. Witness examinations, document productions. I don't know why you didn't have that here, but there's plenty of times where the Secretary, through a hearing officer, actually conducts an adjudicatory hearing.
They
on these
did.
matters.
That's not how the hearing officer conducted it. He just asked for pre-hearing
Did
briefs.
you ask for a hearing?
Did I ask for a hearing? No, I did not. But that is the process. That was the process all the time, and that's what we did, and that's what we do. It's not my burden to prove that they did not comply.
It actually is, sir.
Well, actually,
Excuse me for a second.
I'm
There's a
sorry.
presumption of regularity with regard to governmental proceedings, and you have to rebut that presumption if you're challenging it.
Well, no, if I am challenging, I challenge it on due process. They did not hold the hearing. In fact, it's in my briefs again and again and again, the due processes, that they did not comply with it. They did not hold the hearing. There was no hearing officer present, that they completely circumvented the school.
What do you mean there was no hearing officer present?
I mean, there was no school board members present at the hearing. They completely circumvented it. They had no knowledge of this hearing, of this case, at any step of the way. There is no proof that they did.
Sir, I really want to understand your point there. You're saying they had no knowledge. When did you examine them on their knowledge?
I never had the opportunity to.
And you're saying you didn't have an opportunity to do it with the Secretary?
I never had an opportunity to speak to them.
You couldn't, okay. I guess that's a question of whether you could have had the adjudicatory hearing at the Secretary and subpoenaed them to testify in person in front of this hearing officer and asked them the question.
I did not do that because the Secretary has always done the hearing on the record stated below.
Okay, do you have anything more you'd like to tell us?
Yes. All right, this is the importance of a school board hearing, and it is mandatory, and it is always, every decision of this court has been since 1938 in the Swings case that there must be strict compliance with the procedural safeguards, or it is a fatal defect, and it is a denial of due process. And the Jones court that relied in this decision relied on Jones, and they explained that to the school district that they must have school board members. Every case from Twer to Smith to the Neshaminy case, they are all cited in our brief to this court, in our brief to the Commonwealth Court, in our brief to the Secretary of Education, and our brief to the school district's hearing officer. There is no evidence of any compliance with the school code. And that is a denial of due process and a denial of, that is no compliance. And Justice Doherty, just so you hear it, right? I argued in every brief it was a complete circumvention of the school code and a denial of due process to this court, to Commonwealth Court, to the Secretary of Education, and the hearing officer for the school district. If this court rules in favor of the school district, it will make those procedural safeguards illusory and meaningless. It will eviscerate the plain meaning of the school code. And they are mandatory, and they are guaranteed by the 14th Amendment as fully explained in Jones. The court fully explained it. It's not optional to the school district to decide that they don't have to abide by the explicit, unambiguous language of the school code. That's a violation of due process. The state, he has a property right to his employment. He cannot be denied of that property right and a liberty interest in that, in the procedural safeguards for any reason. Okay? The school district never raised that issue that they're arguing before you at any point until council argued it in their brief in this case. We have the Twer case. We have the Pittenger case. All the cases that I cited. No case that the school district cited is applicable to this case at hand. Every case that I cited in my brief is applicable to this case and sets forth controlling precedents, including the one from Loudermill, which Commonwealth Court said time and time again that those safeguards must be strictly complied with, or is it a denial of due process? And Commonwealth Court said in the Jones case, they explained Loudermill, they explained Roth, and Mr. Follman has a property interest in his employment. Every paycheck. He has a liberty interest in his reputation at every step of the way. The school district complied with none of them. And if I'm going to repeat what I said to Commonwealth Court in Jones, and I repeated it again in this case, and I ask you to listen to my closing statement and my summation of this case to you. All right? This is the holding in Loudermill, the United States Court in Loudermill. If a clearer is, and I want to read it to you, so it reverberates from the rafters of this courthouse to Constitution High School to the Liberty Bell and resonates throughout Philadelphia and throughout our Commonwealth, Pennsylvania, because every teacher's due process rights are at stake here today. The school district is asking you to rewrite the procedural safeguards for their benefit. And this is what my final words to you are this, Justice Doherty, Justice Weck, I've read your decisions, I've read all of your decisions. They are great decisions. If a clearer holding is needed, we provide it today. This is the United States Supreme Court. The point is straightforward. The Due Process Clause provides that certain substantive rights, life, liberty, and property cannot be deprived except pursuant to constitutionally adequate procedures. The categories of substance and procedure are distinct. Were the rule otherwise, the clause would be reduced to a mere tautology. Property cannot be defined by the procedures provided for its deprivation any more than can life or liberty. The right to due process is conferred not by legislative grace, but by constitutional guarantee. While the legislature may elect not to confer a property interest in public employment, it may not constitutionally authorize the deprivation of such an interest once conferred without procedural safeguards. Our legislature have enacted strict, explicit, unambiguous procedural safeguard. It is not for this court to rewrite the procedural safeguards. We raise those issues at every step of the way. The school district knows it, the hearing officer knows it, and I put it in, and it's in the record at every step of the way. You know what,
I thought you
Neil Follman?
made your final argument a while
I just make one more sentence.
I heard the word final a while ago.
Can I make one final statement?
Yes,
I'm not the chief, so.
yes.
Okay.
One.
If Neil Foreman had his hearing before the school board in an open public meeting, his students at Constitutional High would have came to that hearing, and I would have asked one of them to testify on Mr. Follman's integrity, honesty, and forthrightness, and that he is a great teacher.
Well, hypothetically speaking, just to get off the subject, what was the issue before the court? You're introducing character evidence?
No, that he had a right to a hearing before the school board, that they could ask him questions, that they could say something, that he would have then called him. He could not, there was a provision that when he got suspended, that he was not to contact the kids at school. They would have came to the hearing before this thing,
I understand.
and I would have asked them. That was his right for a hearing before the school board, and it was everybody's rights. The interests here are the students to have good teachers. Is all he wanted to do was get his COVID surveillance test done through his own doctor and present the test results.
Was your client deprived of the opportunity to call students at the hearing in front of the hearing officer?
He could not subpoena them.
Why not?
Because he doesn't have their addresses, he doesn't have the phone numbers, and he was told by his supervisor at the school district not to contact anyone at the school. That's what he was told when he was suspended.
Well, I assure you, we will look at the entire record, and we will take this case under advisement. Thank you, Mr. McGlure.
And thank you very much, respectfully.
All righty. Thank you all. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Tristan Glenn Myers. Representing Mr. Myers, Mr. Anthony Tamburino. Representing the Commonwealth, Mr. Edmund Peace.
Have apparently cleared out the courtroom.
I have that effect.
Good afternoon.
Hopefully not to the justices.
We're still here. In this case, appellant was charged with persons not to possess a firearm and other offenses. Prior to a stipulated bench trial, appellant sought to correct the Commonwealth's calculation of his standard sentencing range, alleging that one of his prior disqualifying convictions for the firearms offense was impermissibly double counted in his prior record score. The trial court denied the motion, finding that appellant's prior conviction was a precondition and not an element of his firearms offense. Thus, the court reasoned that the inclusion of the prior disqualifying conviction in the calculation of appellant's prior record score did not run afoul of the policy against double counting. The Superior Court affirmed in a split en banc decision. Before us, we must first address whether appellant's claim is to the legality of his sentence, over which we have jurisdiction, or to the discretionary aspects of his sentence, over which we do not have jurisdiction. If we have jurisdiction, we are asked to address whether the Superior Court's decision in agreeing with the trial court that appellant's prior disqualifying conviction was a precondition of his firearm offense and not an element for the purposes of sentencing was inconsistent with our decision in Commonwealth versus Jemison. Please proceed.
May it please the court, Chief Justice, Attorney Wiest. My name is Anthony Tamburino. I'm with the York County Office of Conflict Counsel, and I represent the appellant, Mr. Myers. I would address the court's the question that the court raised sua sponte on jurisdiction. I would note to this court that I have advised Attorney Wiest that I have found an additional case, Moses v. District Attorney of Philadelphia. I advised him a week in advance that I had found it, and it is related to the jurisdiction issue as well as just generally the double counting issue. I have provided copies of that decision to the court. I did not believe it was appropriately fit under 2501 as a post-submission communication because it's from the Third Circuit, so it would be persuasive to this court.
Yeah, we're having trouble hearing you there.
Sure. So I believe it is a legality of a sentence issue to double count factors in the sentencing guidelines.
If you go back a minute, did you say you are submitting a supplemental case or you're not? You said it's not binding on us, it's Third Circuit, but did you cite it?
I didn't cite it in my brief. I did find it afterwards. I did advise Attorney Weiss that I had found it a week in advance. I did bring copies for the court. I did give them to the prothonotary. I can simply put it as a post-submission communication and file it that way, or if the court would like me to discuss it, I can.
No, we've got it, thanks.
Okay, thank you, Your Honor. So I believe the sentencing guidelines anchor a court's discretion, and thus it would be an illegality of sentence issue. Sorry, the sirens are a little distracting.
They are.
And I hope they have no disqualifying convictions under 6105. It's been a long day, Your Honor.
For us too.
I apologize. So,
No, you know what? We have all the time in the world, sir.
well, I will try and make this as quick as possible. I think under Commonwealth v. Taylor, which is this court's case, and Molina Martinez versus United States, which is a Supreme Court case, they're both aligned. I think that demonstrates that this is a legality of sentence issue. The General Assembly established in Taylor that there was a mandatory sequential sentencing scheme that must be followed, and that a sentence in the statutory range doesn't matter per se to make it a legality of sentence issue. In Molina Martinez, they said that an unpreserved error in calculating sentencing, even when a defendant is sentenced in the correct range, he's not required to provide additional evidence that the error affected his substantive rights. As I said, this anchors the court's discretion, and that's why this is a legality of sentence issue when there's double counting. In Moses v. Philadelphia v. District Attorney's Office, which cites Molina Martinez, the Third Circuit dealt with this issue in regards to Jemison and Kuiper directly, and it said that because this court had not decided on whether Jemison applied to sentencing, but the essential element test applied to trial, that it couldn't really see any reason. I believe the exact words it used was, but in law, as in life, sometimes the most straightforward interpretation is the right one, and there is a distinction between, if there is a distinction between a precondition and an element, it eludes us. Kuiper and Johnson both dealt with a precondition type argument, which were both decided before Jemison. This court very clearly said in Jemison that the prior disqualifying conviction under Section 6105 offense is an essential element. I think the fact that it's an element in itself demonstrates that it falls under the offense gravity score, because the definition of an offense gravity score clearly says that it takes into account the elements of the offense.
Assume that's right. How does that help you? What's the constitutional or statutory prohibition on this double counting?
Well, under the Crimes Code, under Section 104, the legislature indicated that that the purpose of the Crimes Code was to safeguard offenders against excessive, disproportionate, or arbitrary punishment, and to give fair warning of the nature of the conduct disclosed.
I mean, now you're going to purpose, and nobody would dispute those general principles. What is the constitutional or statutory prohibition on this counting?
On double counting?
What are you calling double counting?
Well, it's the general policy under the guidelines that there's no double counting. And
well, I didn't ask you about the guidelines. don't dispute the guidelines are advisory, do you?
Correct. They're an implementation of what the legislature is.
You're not even standing on the guidelines, you're standing on some commentary to the guidelines, aren't you? That's where this language on page 194 of the commentary comes.
Well, the elements of the offense are a due process issue because they have to be proven beyond a reasonable doubt. So,
I'm saying assume you're right, sir, assume you're right and Kuiper's wrong. What is it about this so-called double counting that violates the Constitution or any statute?
well, I think it violates the sentencing code in that we have two sections that indicate, in the sentencing code itself, under 2154, which indicates that 2154 indicates that the seriousness of the offense, the sentencing range is applicable to the crime given the degree of gravity. So if the element is part of the gravity of the offense, that's been implemented through the offense gravity score.
Well, and aren't you arguing or alleging that there would be potentially an 18-month difference in the length of the sentence?
There's a minimum of a 6-month difference if you look at the maximum 42 months for the lower prior record score and the lower end of the higher prior record score. But in total, yes, it would be 18 months because his maximum, he was sentenced to 5 years. He was sentenced to 60 months.
So how is that, just so we understand your argument, how is that violative of the sentencing code?
Well, because it would be outside his proper guidelines because the prior disqualifying conviction under 6105 is an element of the offense.
But again, you answered the Chief's question about the code by citing a guideline. And if there's no change in the grading, I don't see not only is there no constitutional issue, but there's no statutory violation. You're defaulting to the guidelines. There's no grading change. So this where the grid comes out is irrelevant to any alleged statutory violation here.
Well, I think it is when you look at the cases that relied on Kuiper, which looked at it from the prior record score side of things. If you don't look at what happens in the offense gravity score side of things, if this court says that the prior disqualifying conviction is an element of the offense, then it's being added in both sides. It couldn't be in any clearer example of double counting. I mean, if we consider that it's double counting because we're not going to move to a completely different matrix in the deadly weapon enhancement because a weapon is involved in the offense, then it would seem to be it's a much clearer indication of double counting when you literally add it to one side of the axis on the main matrix and add it to the other side on the other matrix. So to me, there's no question that would be double counting.
Just one more on this, and I'll leave you alone for a minute. The 3038G specifically, and that's the guidelines, specifically talks about an increase in the grade. So by implication, aren't you out of luck because there's no increase in the grade here? I mean, you seem to want to rely on the spirit of the laws, not on the letter of the law. Am I wrong?
Well, no, I don't think that's relying on just the spirit of the law because, again, the guidelines lay out specific examples of double counting, but they're not the only examples of double counting that are possible. Again, both under the guidelines and under the en banc court and Superior Court decision in Goggins, it's a general policy against double counting. So there can be other places where there are double counting that have not been discovered yet, and we discovered that there's a potential for double counting here with this court's decision in Jemison. It makes sense that Jemison would apply straight through from trial to sentencing if one of the elements of the offense is the prior disqualifying conviction. It's what was needed for proof beyond a reasonable doubt to convict him, so it's part of what's taken into account in his offense gravity score at the time of sentencing.
So where are you indicating the illegality of the sentence occurred? Based upon Justice Weck's argument, 3038, It can't be counted in the elevation of the grade, which the 6105 remained in F2.
Well, this court has said that it's not required to go outside the statutory guidelines for a sentence to be illegal. It did that in Taylor.
But that would be a discretionary aspect of sentence. I'm looking for the illegality.
Well, in Taylor, they said it was an illegal sentence when the court didn't follow the specific statutory guidelines to have an assessment prior to sentencing. So here, what the argument would be is that you can't add something to both sides of the sentencing matrix and not say that it's double counting. That would make it an illegal sentence. You're punishing him twice. You're double counting what his punishment is based on the offense gravity score, which has the element factored into it, and then adding it back into his prior record score as a prior offense. I mean, in this particular instance, trial counsel filed the motion to correct the guidelines up front, but that's not what would normally happen. A defendant would discover this well after the fact. They would see a prior record score and suddenly realize that they're subject to far greater of a penalty than what they realized. In this case, trial counsel tried to do it up front because he wanted to help his client decide whether he should take a deal or go to trial. So under those circumstances, I think that can be an illegal sentence because, again, we're not talking about a court can't ignore the definition of what the guideline says about the elements of the offense. The guideline definition says the elements are included in the offense gravity score. That's based on the legislature, the General Assembly's decision to make it an element of the offense. So under the circumstances, that would be a legality of sentence issue.
I'm struggling with your argument because I see your point about potential unfairness of the sentence given the error that was made, but I'm not getting all the way to why this is an illegal sentence.
Well, because it's one thing if a court uses impermissible factors in sentencing, and I believe the Commonwealth cited a few examples in their brief. They cited Smith, they cited Walls. But that's different than using an incorrect factor here. And the incorrect factor here is adding into the guidelines, the prior record score guidelines, something that was an element of the offense. So under those circumstances, it's a clear example of double counting. When we call it a gradation, when we raise the gradation based on the offense, we say it's double counting. That's not clearly as obvious as it is here where it's sitting on the same matrix. When we move it to the deadly weapon enhancement matrix, we say that's double counting. For example, also in Goggins, when the court said, the en banc superior court said, the mandatory minimum takes into account the prior convictions. You can't then aggravate his sentence based on the fact that he had multiple drug offenses as prior convictions.
Okay. Other questions? Do you have any more argument for us?
Other than what I stood on my briefs, no, Your Honor.
All right. Thank you very much. Let's
Thank
hear from Mr. Weist. I may or may not have pronounced your name correctly.
It is Mr. Weist, Your Honor, but I appreciate the clarification.
It was a good faith try.
75% of people get it wrong, including parts of my family. Good afternoon, Madam Chief Justice and Justices of the Supreme Court, Attorney Tamburino. As we've already established, my name is Edward Weist, and I'm privileged to be here on behalf of the Commonwealth of Pennsylvania for this case and for what is my first oral argument before this court.
Well, that raises a question. Your office usually sends ADA Lombardo. She was not willing to do it this time? She had enough of us?
She is no longer employed with our office. She left a couple weeks ago to go into private practice, Your Honor.
Well, that certainly explains it. Well.
Yes. I will note, Attorney Lombardo, I hope you'll fine-train me well. I miss her dearly, and I hope I do her brief and her advocacy before this court justice.
She always did a fine job before the court.
Yes.
Now it's your turn.
It's my turn to hopefully fill those shoes as best I can. With all that being said, Your Honors, The best expression of the General Assembly's intent is in a statute's plain language. And this is a case where I think the plain language is where this analysis begins and ends. The specific term that we're trying to define and give meaning to is prior conviction. And in the terms of the sentencing code, the term prior conviction has a very specific meaning. It is a legal term of art. We've been referencing section 303.8 of the Sentencing Commission's regulations, and in that section, specifically subsection A1, it says that the term prior conviction is defined. It's defined as previously convicted, incorporating the statutory definition in Title 42, section 2154F. 2154F says that that previously convicted means any finding of guilt. Any finding of guilt. This is not a very gray issue in the terms of the context of this case. This is not, for example, when does a block of wood become a component part of a firearm? In the context of this case, Your Honors, this defendant was adjudicated guilty. I forget if he entered a guilty plea or if it was after a trial that he was convicted of possession with intent to deliver a controlled substance. The point is, there's no dispute that this is a prior conviction. Now, because a prior conviction means any finding of guilt, that's your general rule. If a prior conviction is any finding of guilt, you count it in a defendant's prior record score. If you move down to 303.8G subsection G3, those points specifically elaborate what the exceptions are to the rule. What prior convictions are not counted in a prior record score? And there it says specifically, subsection 3, any prior conviction which contributed to an increase in the grade of the subsequent conviction. That is specifically carved out by the Sentencing Commission as what is not to be counted in a prior record score. It does not say if something was an essential element of the offense. I note with regard, the defense has made some argument in terms of Jemison. I want to go back a little bit further to Commonwealth versus Johnson and Commonwealth versus Kuiper. These are the Superior Court cases that previously ruled on this issue before this court took the issue up in this appeal, that both found that the distinction between precondition and essential element. I note Johnson was decided in 2000. Kuiper was decided in 2005, which means from the Johnson decision, we have 26 years that we've had a decision noting that this precondition and element distinction exists, and our legislature and our Sentencing Commission have done nothing to overturn them. There was previous reference in another argument, I forget which one it was, about legislative acquiescence to previous decisions by the court. And here, where we've been operating for 26 years now under the Johnson-Kuiper framework, and our Sentencing Commission has not redefined this at all, Your Honors.
How can, I don't know that you want to really rely on Kuiper, but I mean, you do, I guess, but I don't think you need to. I guess my question is, how a necessary component of a criminal statute can be an element during trial and then become just a precondition at sentencing? It seems a bit of sorcery. If it's an essential element, I mean, put it this way, if it's an essential element of trial, doesn't it have to be an essential element at sentencing?
No, Your Honor, because ultimately, the language at issue here in the sentencing code is prior conviction, which I won't repeat what I've said before. Prior conviction and essential element are two very different things. Two very different things with very different definitions. I think the opinion in support of affirmance in the Superior Court said it very well on page 541 of their decision, if you go by the Atlantic Reporter, and I'll quote them word for word. Even if appellant's prior felony drug conviction constitutes a material element of his Section 6105 charge, the trial court was not precluded from including it in the appellant's prior record score because it did not elevate the grading of his persons not to possess offense. The precondition versus essential element distinction really doesn't matter here.
That's my point. Why do you have to stand on this this precondition mumbo jumbo? Why can't you just defend the sentence on the basis that there's been no grade change and we're done, without having to invent this Kuiper? Well, you didn't invent it. Kuiper invented it. Without standing on Kuiper's invention about a precondition.
I agree with everything you've said, Your Honor. I note Kuiper and Johnson. One, in the alternative, if this court does not agree that plain language resolves the dispute, and we do have to get to canons of statutory interpretation, the fact that the legislature has not changed, or the Sentencing Commission has not changed the regulation here, does speak to their intent that they agree to some extent with Kuiper and Johnson. That's what I use it for, Your Honor. But I agree 100%. We don't need to get there because the plain language is the plain language. I think that's further noted by the deadly weapon enhancement. When the Sentencing Commission desires to have a specific element not get double counted, referring to, this is 303.10 in the Sentencing Code, that there shall be no deadly weapon enhancement for any other offense for which a deadly weapon is an element of the statutory definition or sentencing factor considered in the OGS. Now, what that means, Your Honors, is that, for example, an aggravated assault, A4, so the theory of causing bodily injury with a deadly weapon, there would be no deadly weapon enhancement for such a crime because the deadly weapon is inherent in the crime. That's what defense is trying to argue here. The problem is the Sentencing Commission specifically carved this out for the deadly weapon enhancement, but they did not make this a general rule across all charges for everything, Your Honors. They did this specifically with the deadly weapon enhancement, but they did not do it generally. So specifically, where the legislature includes specific language in one section of a statute and excludes it from another, that language should not be implied where excluded. Another canon of statutory interpretation, which, again, I note, Justice Wecht, I don't think we need to get to the canons of statutory interpretation here, but it further bolsters the argument. I think I've belabored the point on the substantive issue. If the court wishes me to address the jurisdictional issue, I'm happy to do so if there's any questions. Otherwise, I am honestly content to rest on my brief on that.
Let me ask you a question.
Yes, Your Honor.
Is there a policy against double counting?
There is, Your Honor, and I note that that policy, Justice Wecht previously referred to, I think it was page 194 of the commentary. That specifically notes that that policy against double counting is embodied in the subsection G3, which specifically says it's a prior conviction which contributed to an increase in the grade of the subsequent conviction. So where that comment that indicates what the policy is specifically tied to the language that the defense wants to try and get around, that it doesn't, or that in order to not be counted, it has to increase the grade. They've linked it so tightly, it's hard to say, Your Honor, that there's that policy is embodied in something broader than the specific language of the regulation.
All right, any other questions for Mr. Wiest? Thank you both very much. Well done. Yeah. Oh,
Thank you, Your Honor.
Right.
Thank you.
Safe travels back to York.
Thank you, Justice. I appreciate it.
To adjourn court, Mr. Minner.